May I please, Your Lordship. Lordship, item number 4, for admission, the affidavit filed by respondents I received on Wednesday. I have gone through the affidavits this morning, but I need to file a reply affidavit to, my Lord, refuse certain contention. So a week's time will be given. By then, I'll be able to file.
What is the matter about?
My Lord, land ownership. The issue is, Lordship, this is the third round of litigation. Firstly, Lordship, back to our appointment, then 4 persons were appointed who were not landowners. So the landowners approaches the Honorable Court against that order. And then this Honorable Court gave a direction to conduct an interview in accordance with the standing guidelines. Thereafter, Lordship, an advertisement was issued. But in that advertisement, it is totally silent about the preference for the land ownership. And there's a direction of this Honorable Court in some others, in other court, in another case, that when it poses its priority should be given to the landowners if eligible. Accordingly, my Lord, the advertisement I challenge again in the second round of litigation. This Honorable Court set aside the advertisement and give a direction to issue a fresh advertisement where a clause should be included that preference should be given to the landowners if found eligible for appointment. Thereafter, interview was conducted, Lordship. In the interview, it was purely on the basis of merit. No preference, nothing was given to the landowners. Though they were eligible and they appeared in the interview before the interview. That is the issue, Lordship. Now,
but Mr. Takuma, sir, where is the concept of having an advertisement for land ownership?
Lordship, I'm going by the judgment of this Honorable Court.
Understood, but you see, land ownership is a different, it is not, the moment you put the land ownership in the advertisement, you make the land ownership concept a source of recruitment. You cannot have, you see, just for example, a compassionate appointment, land ownership, these are not sources of recruitment. These are granted on the basis that the government has a policy that in respect to compassionate appointment, the bread owner, the sole bread earner having died or expired out there, so therefore to provide a succor for that. Similarly, land ownership is, if you have an oral agreement or a written agreement prior to 2005, then this, and the government at that point of time had promised that, look here, we are going to give you some land in relation to the land donated free of cost. Then in that regard, the government says, okay, we'll appoint them. But if you put them within the scope of land ownership, of a recruitment process, it will become a different aspect.
My Lord, in that view, automatically allow me to file a reply affidavit because, Lordship, a balance has to be maintained because, my Lord, on the one hand, Lordship, I accept that the concept of advertisement is there. On the other hand, we have a policy. So there should be a balance to ensure that, my Lord,
Mr. Takama, sir, the question of the policy being there is okay.
Lordship.
It is similar to a compassionate appointment.
Lordship.
There's no difference of that. It is a source by which it will. The moment it becomes an advertisement, you are making the land ownership concept within the ambit of a resource of recruitment.
The question is, in terms of direction of this Honorable Court, in terms of direction of this Honorable Court was give a direction that condition should be included in the advertisement. Accordingly, in compliance with the direction of this Honorable Court, that advertisement was given, whereby that is one of the specific conditions. So, Lordship, it's a very... Can you allow me to file a reply?
Because maybe there has to be a recommendation being made under 3B by if it is an oral agreement by the Deputy Commissioner.
Well, there's a written agreement. If
it is a written agreement, then they have to consider it the horse.
On that point, can you allow me? Initially, my Lord, in terms of 3P, there was a letter written by the director for the petitioners that can be verified through Deputy Commissioner and put up. But instead of doing that, he gave backdoor appointment. That question is also, that document is also there in the petition.
So if that be so, we
my Lord,
interfere with it.
My Lord, kindly allow me to file a reply affidavit because that it may have a bearing in all the land ownership appointment because of late lordship, this honorable court has been giving direction for advertisement, keeping in. So that balance has to be maintained. So, my lord, in that view of the matter, 1 week's time I'll file. I could have filed earlier, but it was received only day before yesterday, on witness day.
Now,
My clients live from.
what is the respondent's stand? You
My
are
lord,
filing?
the respondent's stand, one of the stand taken is that some of the landowners had been given privilege, so we are not entitled. But that is totally wrong, my lord. At no point of time, several landowners, the petitioners, at no point of time had enjoyed any facility in terms of 3A country.
So the stand of the state is
Then secondly,
comes under 3C.
Secondly, the second stand taken by the state government is that the direction of this honorable court, that priority should be given to the landowners if eligible to be considered for appointment. It is the stand of the government in the affidavit that priority should be given only if the merit is same in the interview. And if the merit is not same, then priority cannot be given to the landowners. If we go by that.
No, in fact, that is why the problem has arisen. The coordinate bench who have passed that order, the problem has arisen because the coordinate bench brings the land ownership concept within the ambit of a source of recruitment, which couldn't have been done.
Exactly.
And the moment you are doing it, then it will be when the merits are equal, then you go for.
Because the issue is this. The issue is this. Lordship may kindly appreciate. We need a proper decision on this because there has been contradicting judgments from this honorable court over the years, last 5. On the other hand, the direction for direct appointment without interview. On the other hand, direction to conduct interview. So, my lord, in that view of the matter, lordship, now the first judgment by Justice Silo, direction was that conduct an interview in terms of the starting guidelines. In other words, that is inclusive of the office memorandum on land ownership. But then in the first advertisement, that was not given. So I came back to this honorable court, and there is a direction by another coordinate bench of this honorable court that in the event any interview is to be conducted, priority should be given to the landowner if found eligible for appointment. So relying on that judgment, I came back again before this honorable court, and in the second round of litigation, and in the second round of litigation, this honorable court accepted that view and give a direction that in the advertisement should be included, reiterating the earlier judgment of Silo, Honorable Justice Silo. So, my lord, whichever way, my lord, in the long run, it will have a bearing on the whole issue.
Mr. Takawasi, yesterday also I delivered 2 judgment on land ownership. I made it very clear that the source, it is not a source of recruitment. It is a policy of the state that they would be given. So therefore, you cannot bring them within the source of recruitment. The moment you bring it, then the question comes of equal being there and all these things.
Well, Lord, in that view, but the kindly allow me to file a short affidavit because.
Okay. Mr. Takamasa, the learned senior counsel, who submits that the respondents herein have filed an affidavit in opposition. The respondent state had filed an affidavit in opposition.
And the private respondents also.
Wherein it is mentioned that the persons from the petitioner's family have already availed appointments on land ownership basis, and as such, they are not entitled to be considered on the basis of or in terms with the notification dated 5/3/2018. The learned senior counsel therefore submits that he would like to file a reply. How much time?
A week's time, Lordship.
2 weeks' time is granted to the petitioner to file the reply. List the matter upon filing of the reply.
Much obliged, Lordship.
So, Chief, if I may be allowed to mention a hearing item on behalf of my colleague, 13, 14, and 15. On behalf of
13 matters.
Livika.
What matters are these?
Your
What are
Lordship,
these matters? These are matters of 2000. You can
I
adjourn
think the
it.
petitioner will be in a better position because I don't have the brief with me.
Don't, you take you look into my brief. We have a second copy. Look into it.
Then, Your Lordship, I have personal difficulty as well, Your
Okay,
Honor.
don't appear.
So-
We conduct without the state government. You have to matter. 2000 matter, we are not going to adjourn. Sorry.
May I please, my lord? My lord, pertaining to item number 12, orders column, I have filed the affidavit in opposition as directed by this honorable court. With your lordship leave, if that may be bring on record. If
Yes, Your Worship. I beg to mention item number 20, Your Worship. Your Lordship, this item was actually supposed to be listed on 20th of April. But it appears to have been wrongly listed for today.
Which one?
Item number 20.
in the supplementary list, your lordship.
Matter pertains to what?
Item number
Regularization, your lordship.
Huh?
regularization, Your Lordship.
No adjournment. Next.
For admission, item number 1.
May I please, my lords?
Hmm.
My lords, there are two issues involved in this case, my lords.
Hmm.
My lords, actually there are three issues. One was virus of a notification. For a moment, my lords, if that is even kept aside for a moment, while I am covered on that by my lord's judgment, but I am keeping it aside, my lords, because that is pending in Supreme Court. Even on the merits of the matter, my lord, in my own cases, in several cases, this court has allowed my petitions on the basis that subsequently Parliament itself has amended the law to give me the benefit. My lords, that compilation my friend is carrying. In my own cases also it is there. My lords would recall that there was a time limit for my lords availment of input tax credit. But because there were certain confusions during initial years, the Parliament amended and introduced a specific provision, section 16, subsection 5. And my lords, by virtue of that, I am squarely covered within that, and therefore the benefit has to be allowed. That is point number 1, my lords. In point number 2, my lords, now the Supreme Court again has settled the law on merits. So, my lords, what happened in this case was that inadvertently, my lords, 4 invoices that my lords, there is a government of my lords India undertaking, Messrs. ITI, who is the petitioner before my lords. My lords, it raised invoices on another government of India undertaking, namely BSNL. My lords, on these supplies, the rate applicable is 12%. There is no dispute on that. And invoices did mention 12% only. But my lords, what happened inadvertently, my lords, while filing the detail of invoices on the portal, the clerical error happened and 18% was mentioned. But while my lords recall that this invoice detail goes in GSTR 1, but when actual tax is paid, it is GSTR 3B, my lords. At the time of filing my 3B, my lords, I corrected that. The turnover remained the same. Tax was now offered at 12%, my lords, and it was paid. Again, there is no dispute. So, my lords, the Honorable Supreme Court has said that in such inadvertent errors, you ought to allow the assessee to correct these errors. So, when assessing authority issued notice to me, I gave all these details that this is the invoice, this is 12%. He doesn't dispute anything. He simply says because you yourself showed 18%, therefore the liability is confirmed. Now that aspect also stands, my lord, settled by Supreme Court. One by one, if my lord would permit, I'll show that. My lords. If my lords would have, my lords, page number 387.
Yeah, Mr. Agarwal, you're raising so many points in this petition. First,
Well, actually, yes.
the case of 56.
That's right, my lords, which is covered by my lord's judgment. But my lords, on the last occasion, were my lords kind enough to say.
One is 56.
That's right, my lords.
Second is an order passed in consequence to 56.
That's right, my lords. That's right.
That is okay. That is why you have not gone under 107.
That's right, my lords.
Now, the remaining aspects which are there
Yes.
are in connection with what?
My lords, what happened, my lords? Even for that purpose, my lords, several notifications came to be challenged, and this honorable court granted interim to me in several years and in several cases. and finally allowed my writ petitions, my lord. Even the my lord's principal bench, division bench, my lord, judgment is there in my favor in my own case
No, no, no. Kindly
on
come.
that issue.
No,
On
Mr.
16.4 issue, my lords.
Agarwal, kindly come to para relief number Roman 4.
That's right. I'll just give me one moment, my lords.
An appropriate read direction and order may be issued declaring the impugned notification dated 23/17.
That's right. That's
dated
right.
unconstitutional.
That's right, my lords.
What is this notification to?
My lords, today, my lords, now I can just turn to that, but just to clarify, my lords, now Parliament itself came to the rescue and corrected the position.
So therefore, it is not necessary.
Today, my lords, therefore, my lord, this honorable court
Because
has passed orders.
as per section 16.5, which has been.
That's right, my lord.
It has
That's
already been.
yes, my lord. For my lord, what happened was 17, 18, 18, 19, etc. years are covered by that 16.5. Yes.
No, Mr. Kindly come to number 5.
That's right, my lords.
5 would not cover my judgment.
No, it would not. My lords have considered
In
56.
fact, the challenge which have been made by as regards 5 has already been turned down by various high courts.
That's right, my lords. That's right. But my lords have not considered it till date.
No. Number 6 is again the same as number 2.
My lords, one moment, my lords.
What is number
My
1?
lords, 2 is 72 notification, my lords, which again, my lords, I am saying it
What is
because
this,
of 16.5.
What is this this appropriate redirection as regards 49 of 2019?
My lords, what this actually, my lords, these are all, my lords, notifications which created difficulty, but 16.5 corrected it, my lords.
So these are all being taken care of.
Yes, for 3 years they have been taken care of.
So therefore, all the relief at 1, 2, 3, 4, 5 doesn't remain in view of the amendment to section 16.5.
My lord, 5 is that period notification, my lords. That would have to be considered.
5
at
is
the
there,
bottom.
so we
That's
removed that 5. Then
That's right. That's right. And 6, my lords, I have held in my favor.
already covered. Now
Yes.
7 is
So,
the
my lords, I have to get the
order
consequential
on the
relief,
basis
my
of
lords.
5. So, 7 is the consequential
Consequential
order
relief,
on
my
the
lords.
basis of 6.
That's right.
Then the remaining are there. So the only thing which remains out here is 6 and 7.
My lord, 5, 6, and 7. 5, 6, and 7.
5 we rejected right away.
No,
6
my lords have not considered it, my lords. But it will not be
rejected it
required
right
to be
away.
seen in
And
this case.
we closed the writ petition on the basis of the judgment of 6 and 7.
That's right, my lords. That's what I'm saying.
And 5 we are rejecting your prayer.
My lords may not say anything on that, my lords.
Already
My lords, I would submit that my lords may not say anything on that because I am covered even otherwise, my lords. So why, my lords, I am not therefore making any submissions on that. My lords may say that it may be argued in an appropriate case.
Because you see, this 5 has no relevance taking into account if you are challenging 6.
My lords, maybe, my lords, because today, my lords, I was not even. Yes, my lords, are right.
That will be the 5 is for a particular period till the
That's
month
right.
of December.
That's right. My lords may therefore leave it. My lords may leave it.
6 is for for a period post December.
That's right, my lords.
So therefore, if 6 and 7 is the only question,
That's right.
it doesn't remain.
That's right, my lords.
So therefore, only remains is 5 and 6.
That's right, my lords.
So we therefore.
My only request is, my lords,
And we
may
therefore,
consider.
no, Mr. Agarwal, we therefore do one thing.
Yes.
Keep the writ petition pending, but close the prayers from 1 to 5.
My lords, that may not be done, my lords. Why I am saying this?
No, 1 to 4 is already being taken care of by the amendment
My
made.
lord,
And
if that is to be done, then my lords, it may not be kept pending. That may be allowed, my lords.
no, I cannot allow it. Because 6 and 7, although it is covered by my judgment.
Yes, my lord.
Supreme Court is in session of the matter.
So, may I say this, my lord?
But Mr. Agarwal, first of all, we don't appreciate this thing. They're filing one writ petition covering all issues, whatever may be.
My lords are right, my lord. My predicament was that this is one order, my lords, 2018-19. Now, my lords, what happened? This 18-19 has to be, my lords, I can't take these, my lords, submissions in piecemeal, my lords. If today I don't take all the arguments, my lords, tomorrow, my lords, I would be, my lords, I would have that predicament of
You
not
can
taking
very
the
well
ground.
file 2 writ petitions out there. It doesn't.
Lords, against my difficulty was that one order is there, my lords. That was the problem. And therefore, my lords, I requested.
Now, as regards 1 to 4 is being taken care of by because there are various orders also passed by us in
my own case
seat.
also, my lords, that I have given.
Principal seat also.
That's right, my lord.
Order pertaining to in view of taking care of by
That's right.
16.5.
Therefore, my lords, I am saying that my lords may pass the same order which has been passed in my own cases and which my lords have been passing, taking consideration of 16.5. And for me, this challenge to the notification may be kept open, my lords, 56, depending upon what the Supreme Court decides, my lords. That would
Well, which notification? 56.
56, my lords, which is pending before Supreme Court.
No,
This
no,
is
no.
what, my lords,
No,
generally.
56 is okay, but it is although covered by judgment, the matter is pending. So we keep the matter pending out here for 56.
And my lords, then
As
7 may be
well as
quashed.
also, as well as the order which has been passed in consequence to 56, that is 34,
My
2020.
lord, 7 may be quashed. This prayer 7 may be granted to me on the basis that of 16.5. That's what my prayer is, my lords.
So
And that
then-
is what my
then
lords have been doing
56
in my
will
all the
be-
cases. My lords?
So let's say annexure 30.
Yes.
Where is it? Page?
My lords, it starts at page 350. And my lords may kindly come to for the my lords seeing the date, relevant date of the return, my lords may have page 353 to show how I am covered by 350, my lord 16.5.
Page?
My lord 353, my lords.
Okay. Yes.
My lords may kindly have the date of filing, my lords. Relevant is March 2019 return, which is in the table, my lords. In the table at the foot of the page, my lords, March 2019 return, where I claimed the main ITC, which is in question, my lords, that was filed on 13th of March 21, my lords. My lords, singularly on this basis, my credit has been denied. Now, my lords may have 16.5. Which has later, my lords, been introduced by the parliament, which says that I can take credit for 1819 up to, my lords, it says November 21, the provision. May I read it, my lords?
Yes, please.
And my lords, my friend is carrying all those orders passed in my own cases also. My lords, I am reading it, my lords.
Yes.
Notwithstanding anything contained in subsection 4, in respect of an invoice or debit note for supply of goods or services pertaining to financial years 1718, 1819, 1920, and 2021. My lords, my period is 1819. The registered person shall be entitled to take input tax credit in any return under section 39, which is filed up to 30th day of November 21. So, my lords, notice is in the table. I have filed on 13/3/21. And this is the singular ground for denial. So, my lords, therefore, I am saying this order may be quashed on this basis.
Where is it denied?
Yes, my lords, denial is at page 387.
Yes.
My lords may just have in that, my lords, para 6.3 is on page 387, my lords. 387.
Yes.
6.3 is the para. My lords may come straight away to the second last para of this page. Second last. It starts with due date of furnishing.
I think it cannot be denied by the authorities on the ground.
My lord, this is he records my submission. Reasoning is just after extraction of the paragraph on the basis of 16.4. That's it, my lords. Nothing else is there.
So the entire amount
Yes.
has been imposed only on that aspect.
I said, my lords, two things are there. One is this, my lords.
Yes.
One is the 16.5 issue. Second issue, my lords may just have, my lords may come, my lords, to paragraph, my lord, page number 40 of my writ petition. That also is now squarely covered by Supreme Court judgment, my lords.
It's 40.
That's right, my lords. Only two issues are there.
Yes.
Para 93, my lords.
Hmm.
My lords, I have drawn a table which all the documents are there, my lords may just have the figure. In my GSTR 1, my lords,
Mm,
in my GSTR 1, I showed taxable turnover of 7 crore 65 lakh, my lords.
mm.
And my lords, on that, by mistake, my lords, I showed the tax at 18%,
Okay.
which is 68 lakh, my lords, and 68 lakh CGST, which totals to 1 crore 37 lakh.
So you showed 9% each.
That's right, my lord. That's right. That's right.
Yeah.
Now, my lords, may come to the next page, my lords. In GSTR 3B, my lords, I showed outward supply of, instead of 765, 758, which is only 7-8 lakh difference, my lords, 6 lakh 70,000 to be precise. I will, my lords, that I will take separately, my lords. On that, my lords, I corrected my rate and paid the tax 91 lakh. These are both government, my lords. Supplier and recipient both are government entities.
Now, next is outward taxable supplies as reported in table A GST 3B.
3B. This is the actual
the
return, my lords.
amount has come down by around 7 lakhs.
7 lakh, my lord. That was one credit note. That also I have attached, my lord.
Okay, and
Now-
45, 45 and 91.
That's right, my lord. The difference is 46 lakh, my lords.
Yes.
My lords, this 46 lakh is arising for two reasons, my lords. Just below that difference, I have highlighted that. Difference on account of inadvertent reporting of tax on 4 invoices in GSTR 1. Only 4 invoices were inadvertently, my lord, reported at 18% instead of 12%. And the difference because of them was 45 lakh.
Mm.
All 4 invoices are on record, my lord. They have been charged at 12 only. They are at page 250. I'll show them. Then, my lords, the other difference of 80,000 tax and 6,70,000 turnover is because of one credit note which was duly reflected in my 3B. And these were all corrections were mentioned in GSTR 9 also. Now, my lords, he does not dispute this table. This table was before him also, before the learned authority. What he did, he says.
Let us see how ISB covered and jail for the peak fee which returns have been filed after the last date have been frequently here.
My lords, I didn't get
Well,
what
in
my
this
lords are
order,
asking.
Mr. Agarwal, at page 353,
That's right, my lords.
this is only as regards the liability mismatch. That is
That's
number
right. This is the mismatch, my lords, which I showed, my lords.
the mismatch of this amount. So
That's
the-
right, my lords. The exact difference is what I showed to my lords.
Now, why has he come to 46 and here we have 40? Oh, that is what?
That's
46.
right, my lords. I have reconciled it fully, my lords. Ana pai is reconciled, my lords.
So you say that in 4 of the GST, 4 of the invoice notes,
That's right, my lords.
you have mentioned at 18%, which should have been 12%.
In fact, my lords, slightly, my lords, invoices were 12 only. While reporting on the portal, my lords,
Yes,
this is
yeah,
what went
totally,
enter.
you
Invoices
have-
are at page 250, my lords. Page 250.
PB.
250, my lords.
And now, how does the court look into
Yes.
that aspect?
Yes. Yes, my lord. What the learned authority does is, the learned authority cites a provision which, my lords, is neither applicable, and second, it came in 22, which has therefore no relevance to 1819. My lords may have page 386. So there is no dispute to these facts. Page 386. My lords, the last paragraph on this page. Even on merits, I find that allegation made in the demand notice is sustainable. Section 37 of the Act stipulates furnishing of detail of outward supplier in the form of GSTR 1. Similarly, Section 39 mandate that any registered person shall furnish electronically 3B returns specifying inward and outward supply, input tax credit availed, tax payable and tax paid, and such other particulars. Thus, GSTR 1 shows liability declared by a registered person by virtue of his outward supply, and GSTR 3B depict liability discharged by him. Higher GSTR 1 liability construed that some admitted liability has not yet been discharged. So the only reasoning is that because I showed inadvertently an amount in GSTR 1, which undisputedly got rectified in 3B, which is the main return. GSTR 1 is only outward supply statement. GSTR 3B is the return under section 39. The only reasoning is therefore it is admitted. Whereas, my lord, much prior to assessment, I have corrected and filed the returns. My lord, this cannot be a reason. And now kindly see the provision which he cites. Section 75(12), notwithstanding anything contained in 73 or 74, where any amount of self-assessed tax in accordance with the return furnished under 39. My lords may just notice 39 is GSTR 3B, not GSTR 1. Remains unpaid, wholly or partly, or any amount of interest payable on such tax remains unpaid, the same shall be recovered under provisions of section 79. So, my lord, what this provision basically does is if I don't pay a liability which I have reflected in my 3B, the officer need not make an assessment on the basis that it is admitted, he can recover it. But here the fact is he in fact was proceeding to make an assessment under 73. There is no dispute that I have paid entire amount shown in GSTR 3B. So therefore he should have arrived at the correct assessment which is as per my 3B. So this provision cannot be against
Or
him.
in other words, you say that your assessment
That's right, my lords.
is in terms with GSTR 3B.
That's right, my lord. That's the provision is also saying, my lord, 39. If my lords may just have 39, I'll show, my lord, GSTR 3B is mentioned in 39. My lords, the first 39 one itself says so, my lords.
Now
39.
kindly come to the last line.
That's right, my lords. Allow me to read the
For the
which one,
purpose
my
of
lord?
this subsection,
Yes, my lords.
self-assess
The-
shall include
yes.
the tax payable in respect of details of
Detail of outward supply furnished under section 37 but not included in return furnished under 39. My lords, may just notice first thing, this was introduced on 1/1/22. That is much after my period, which is 1819 first.
So this explanation was not there.
Not there. Second, this talks about, assuming for a moment academically, this talks about detail of outward for supply furnished under 37. Detail of outward supply was correct. But the rate was wrongly mentioned, and I have paid full tax on the detail of outward supplies that was reflected, my lords. So detail is not wrong. Detail is correct. The rate was just inadvertently mentioned. So, my lord, this is the second answer. Third, my lords, in such like cases, the Honorable Supreme Court has recently, my lords, held that such inadvertent mistake can be made by anybody directly on GSTR 1 itself, and then following that, division bench of Madras High Court, my lords, has followed that and directly on GSTR 1 allowed to even correct it. So, my lords, may, if considering that my lords today feel that it is required to be corrected, my lords may direct us, we will file that corrected one, my lords. My friend is carrying those orders, my lords. One is called, the Supreme Court is called CBIC versus Abardare Technologies. My lords, my friend is there, my lords, who is assisting me. Abardare Technologies, my lords, and following that, the Madras High Court Division Bench. My lords, may I read, my lords, Supreme Court?
Yes.
My lords, it says, we are not inclined to interfere with impugned judgment, which is in fact just and fair as there is no loss of revenue. Hence, the present special leave petition is dismissed. This was a revenues appeal, my lords. The petitioner, CBIC, must re-examine the provision/timeline fixed for correcting the bona fide errors. Timeline should be realist, as lapse or defect invariably is realized when input tax rate is denied to the purchaser when benefit of tax paid is denied. Purchaser is not at fault having paid the tax amount. He suffers because he is denied benefit of tax paid by him. Consequently, he has to make double payment. Human errors and mistakes are normal, and errors are also made by revenue. Right to correct mistakes in the nature of clerical or arithmetical errors is a right that flows from right to do business and should not be denied unless there is a good justification and reason to deny benefit of correction. Software limitation itself cannot be a good justification, as software are meant ease of compliance and can be configured. Therefore, we exercise our discretion, dismiss the special leave petition, and my lords, contrary view taken by high courts have been considered prima facie do not lay down good law in this regard. And now, my lords, may in this light have, my lord, the judgment of Madras High Court Division Bench. It is by the name, my lords, Principal Chief Commissioner GST versus Deepa Traders, where exactly GSTR 1 was permitted to be corrected.
Where?
My lords, kindly come, my lords, to the facts which are in para 2.
Kindly come to para 7.
That's right, my lord, I come to that. The Bombay High Court in the case of Avardare Technologies had allowed the assessee to amend/rectify the form GSTR 1. Against that order, a special leave petition was referred, which came to be dismissed by order 21 March 25, the one that I read, my lords. While dismissing, the SLP was pleased to observe as under. Kindly, my lords, have the. My lords, should I read this extract again, my lord?
No, you have already.
That's right, my lord. This is the same one, my lord. As held by Apex Court, human errors and mistakes are normal, and errors are also made by revenue. Right to correct mistakes in the nature of clerical or arithmetical error is a right that flows from the right to do business.
Kindly come to paragraph 2 of the.
That's right, my lord. I come there, my lord. My lord, it says the petitioner has, in respect of returns for a few months during 1718, admittedly committed certain errors. Errors are of following nature: recipient GST, GSTIN name has been wrongly mentioned, invoice number date has been wrongly mentioned, Supply details are correctly supplied in GSTR 3 and tax duly remitted. This is my fact, my lords. However, some of the invoice-wise details have been omitted to be reported in GSTR 1. GST was inadvertently remitted under the head SGST and CGST. The aforesaid errors are attributed to inadvertent careless on the part of part-time accountant then employed by the petitioner. The petitioner would also state that errors had been occasioned during the initial months of implementation of GST. Thus, it had no knowledge of condition fully to meet the demand of the system. It was unfamiliarity with procedure and newness in the system that had resulted in commission of these errors. It was only in December 19 that petitioner stated that these errors came to light on account of customer bringing the same to the attention. Admittedly, no details of such reports have been placed on file, though the averment figures at para 5 and 6 of affidavit of the petitioner. At para 7, the petitioner stated that immediately on coming to know of the error, an attempt was made to rectify the return, only to find that there was no mechanism set out under the Act or the portal to enable the same. To be noted that petitioner has averred that tax liability has been met in full based on turnover reported, and it is only the correction of the error that is sought to enable proper reconciliation of petitioner return and annexure with those of third parties. This is Miller, though a counter has been filed above and so and so and so.
Now, can you give me the amendment by which the explanation was inserted to
That's
section?
right. That's right.
75?
Yes, yes, Miller. 16.5, Miller?
Yes.
Yes. Miller, that was introduced. 16.5, Miller, was introduced by.
No, 16.5 I know. 16.5
Yes, which one,
happened
Miller?
recently.
That's right, Miller.
This was, I think, in the 2022.
Millets, this was on the following words have been inserted. Just one moment, Millets, which was published.
2023.
Millets, it appears to be Millets from once it was inserted retrospectively, but the notification is dated 27/9/24.
But it was brought into effect from
1/7/17.
1/7.
Millets, the day when the GST came into effect. 1/7/17, 1 July 17, Millets.
The explanation.
No, Millets, I am talking about 16.5.
No, not on that. I'm saying about the explanation to section 75.12.
75/12. Yes, Millard. That is from 1/1/22. And the notification number, Millard, is I have got the notification, Millard.
Do you have a copy of it? Can you
I have got the notification copy, but unfortunately my friend is not carrying, Millard. I just Millard got it printed. Millard, if I may be permitted to read, it's a 4-line notification. It simply says, in exercise of power under Section 1(2)(b) of the Finance Act 21, central government hereby appoints the day of January 22 as the date on which provisions of Section 108, 109 and 113 to 122 of the said Act shall come into force. So it simply says they shall come into force from 1/1/22. This is not retrospective, Millards, and it cannot be, Millards, because it is putting liability on a person.
So therefore, for taking into consideration,
yes, Millards,
return pertaining to the financial year 2018-19.
That's right, Millards.
They could not have taken into consideration the law which came into force on.
They cannot, Millards, because it is by way of a deeming fiction, fixing my liability. It's not a matter of procedure. It's not a matter of procedure that it is not like you should have filed this return, or he could have called me for hearing or could not have called me for hearing. How many notices he could have been given.
So Mr. Agarwal, the question is like this. Now, you are primarily aggrieved by the order passed.
Mainly, yes. Yes, my lords.
The order deals in two aspects.
That's right.
One is in mismatch in the GSTR 1 and GSTR 3.
That's right, my lords.
And the second is whether you are entitled to claim input credit beyond March 2019.
That's right, my lords.
That's the issue.
That's right.
You filed it in March 2019.
Oh, yes,
and it has been extended subsequently by giving effect from
That's right.
16 by bringing
16.5
bringing in effect from 1/7/2017.
That's right, my lord. That's right.
These are the two issues.
These are the two issues.
Why did we go into all other 56 and all?
There's no need, my lord. That's what I'm saying. My lords may keep those issues open. If at a later date, my lord,
9 I won't.
Not 9, all right, my lord. I have no difficulty on that, my lord.
9
Because,
I
my lord,
won't. The others are being duly taken care of.
That's right, my lords. That is why I pointed out at the outset that 16.5 issue in my own cases, this honorable court has dealt with in respect of various other demands. The matter have been sent to the authority.
I start dictating. In the meantime, you kindly provide your colleague out here by WhatsApp.
Yes, my
that
lord.
notification, because
I'm just sending.
in principal seat we have all the GSTR books. Here,
I know, my lord.
cases we don't have.
Yes, my lord. I'll just immediately send it. Notification.
You kindly WhatsApp it to him so that
That's
he can
right.
speak to him too for
Yes,
that.
my lord.
In
Yes.
the meantime, let me start dictating.
Yes, my lord.
Okay.
Yes, my lord. We have sent it, my lord.
And the other one also, that it has come from 60. Can you just send 16.5?
16.5. Yes, my lord. I am
Ask
sending.
somebody to
My lord,
just
my
put
friend
a
is
photo.
carrying a judgment compilation. It contains 16.5. My lords have extracted it.
Just give it to me.
My lords, it must be in my lord's file also, my lords. We had submitted last time. I'll just mention, my lords, the index will, my lords would find that the index will say, just one moment. My lord, it would be a document contain, my lord, it would be a document having 42 pages and the index is there, which would, my lords, be titled as denial of benefit of ITC should be allowed on account of provision contained under 16.5 of CGST/SGST Act.
Which
It
one?
contains 10 judgments, my lords.
Which one now? Where you are
My lords,
referring to which
third. In the
page?
third judgment at page 11, my lords would find the text, my lords, of 16.5.
Got it.
The first two judgments, my lords, are the division benches, my lords.
And this has been given effect from 1/7, nah?
1/7/17, my lords are right.
Okay. Let me dictate then.
Yes,
You
yes, my lord.
name the other one. Huh?
Yes, I have given, my lords. I have furnished that.
Heard Mr. P. Agarwal, the learned counsel who appears on behalf of the petitioner. In the present proceedings, Mr. So-and-so appears on behalf of the respondent numbers 1, 2, 4, 6, and 7. Because the union can't appear for the GST.
All right.
And
Lord, that was because of notification.
why are you
my lord.
making the GST council a party?
My lords, there is a reason for that, but now
No,
that is not
absolutely
relevant.
there is no reason for that.
All right. All right.
First of all, it is a recommendatory. You know it. It's a recommendatory
All right.
already in there in terms of judgment. What is that the name of the judgment? Mohit Minerals.
Yes, my lords. It is recommendatory body. My lords are.
It makes no sense. Okay, 1, 2, so and so. The present petition has been filed by the petitioner seeking various reliefs. Full stop. The reliefs at clauses 1 to 9, being the main reliefs, are reproduced here in under. It is relevant to take note of that these reliefs have been sought for on account of an order passed by the Assistant Commissioner, Central Goods and Service Tax, Dimapur Division. That is the respondent number 7. Under section 73 of the Central Goods and Service Tax Act 2017, for short, the CGST Act. First, taking into account that the petitioner is aggrieved by the order dated so and so passed by the respondent number 7, this court finds it relevant to take note of the disputes which led to the passing of the said order. It is relevant to take note of that the period in question pertains to the financial year 2018-19. Primarily, there were two disputes. First, as regards the liability mismatch between GSTR 1 and GSTR 3B, capital B. And secondly, that the ITC availed in the GSTR 3B for a tax period where such returns is filed after the last date of availment of ITC in respect of any invoice/debit note as per section 16(4) of the CGST. First, taking into account that these are the two areas in which, taking into account that in these two aspects, the impugned order dated so and so was passed by the respondent number 7. This court finds it pertinent to take note of the said two aspects hereunder. It is an admitted case of the petitioner, first of all, heading below. Liability mismatch between GSTR 1 and GSTR 3B. Heading. It is an admitted case of the petitioner that in the GSTR 1, which pertains to outward details of outward supplies, in 4 invoices, it was shown that the rate of tax was 18%. And furthermore, an additional invoice was reported. However, in the GSTR 3B, which is filed in terms with section 39 of the CGST Act, the said aspect was corrected and the tax component was shown as 12% in respect to the 4 invoices. And the amount and the additional amount which was shown was also reduced. This aspect is apparent from a perusal of paragraph number 93 and more particularly the table mentioned in the repetition. First, the same is reproduced. The table is reproduced here in under. In respect to the said aspect, the respondent number 7 by taking into account section 7512 and more particularly to the explanation which was inserted with effect from 1/4/2022 or 1/1/2022 held that any excess liability shown in the GSTR1 vis-a-vis is an admitted liability and recoverable from the taxpayer. Next. The learned counsel, appearing on behalf of the petitioner, submitted that filing of the GSTR1 under no circumstances can be said to be a self-assessed tax. Rather, those are details of outward supplies furnished. And if there is any mistake committed in the GSTR1, the same can always be permitted to be corrected. He further submitted that in respect to the financial year 2018-19, which is the subject matter of the present adjudication, subject matter of the impugned order, the explanation to section 7512 of the CGST could not have been applied, taking into account that it only came into effect on 1/1/2022. The learned counsel further submitted that if there is a discrepancy in the GSTR1 with the GSTR3B, the various high courts the various high courts have permitted such correction if there is a human error. And this very aspect have also been affirmed by the Supreme Court. In the case of Commissioner Central Board of Indirect Taxes and Customs versus MS Abardare Technologies Private Limited and others, reported in 2025 bracket close 2025 bracket 4 PMI 101. He further submitted that based upon the say judgment passed by the Supreme Court, various high courts have also followed the same principles. And in that regard, have placed before this court the judgment of the Madras High Court in the case of the Principal Chief Commissioner of GST and Central Excise, Superintendent of GST, Goods and Service Tax Network, GSTN, versus Deepa Traders, reported in 2025 4 TMI 1009. On the basis of the same, the learned counsel appearing on behalf of the petitioner therefore submitted that instead of rejecting the petitioner's GSTR 3B on the discrepancy with the GSTR 1, the respondent number 7 ought to have permitted the petitioner to make the necessary correction in the GSTR 1. That is your submission, no, Mr. Next.
My submission is that this could not have been relied. My assessment is there in 3B. So having not disputed that assessment, there is no cause of making any addition. If at all there is a need, I would also additionally correct my GSTR1 on the Millard's direction.
Because you see, the Supreme Court judgment said that
That's
if
right.
there is a human error, you should
That's
allow
right.
it to correct it.
That's right, my lord.
So I think this will be more in consonant.
All
Because
right.
otherwise, then if you want, I can relegate you to the appeal under 107.
No, my lords, no, permit me to correct, my lords.
Yes. So we restrict your submission then to that only.
All right, my lords. All right.
Next. Next. The second submission, the second aspect pertains to non-availing of the ITC in the GSTR 3B for a tax period where such returns is filed after the last date of availment of ITC. It is a case of the respondents. It is seen from the impugned order that for the month of March 2019, for the return filed for the month of March 2019 in the GSTR 3B, the petitioner sought to avail the input tax credit ITC on 13/3/2021. The respondent number 7 in the impugned order observe that the due date of furnishing the return under Section 39 of the Act for the month of September 2019 was 2010-2019. And any return filed beyond this date would accordingly become ineligible for the purpose of availment of input tax credit. In the case of the petitioner, the petitioner filed a GSTR 3B return for the month of March 19, belatedly on 13/3/2021. And as such, the petitioner was not entitled for availing the corresponding ITC, input tax credit. The learned counsel appearing on behalf of the petitioner submitted that the above aspect submitted that though the impugn order dated 30/4/2024 the learned counsel appearing on behalf of the petitioner submitted that the basis on which the respondent number 7 had passed the impugn order is statutorily overridden by the insertion of Section 16B of the CGST Act with effect from 1/7/2017 by the
My lord, this is notification 17 of 2024.
Huh?
My lord, this is called notification 17 of 2024, dated 27/9/2024.
by the Finance Act of 2024.
That's right, my lord.
By the Finance Act of 2024, which was given effect by the notification dated.
My lord, it is dated 27/9/2024.
Are you sure?
That's right, my lords. I have the book in front of me. I'm reading from there.
But here earlier, the Gazette notification is mentioned as 16/8/2024.
My lords, that is for the Finance Act, and the notification that gave effect to it is, my lords, dated 27/9/2024.
The Finance Act was notified was on 16/8.
That's right, my lords. That's right.
By the Finance Act 2024, which was notified
Yes.
by the notification dated 16/8/2024.
Yes, my lords.
And the said provision of Section 16(5) being given effect to, with effect from 1/7/2017 by the notification date bearing number
17/2024-CT.
17/2024 dated 29
27/9/2024. 27th of September.
2024. This court have also heard the learned counsel who appears on behalf of the state respondents, on behalf of the respondents, who submitted that the issue involved in respect to notification number 56/2023 CE. CE, na? 56 56/2023.
CT, my lords. Central tax dated 28/12/23.
26
Page 79.
CT dated 28/12/2023, though have been held as ultra-virus by this court.
This is also under challenge before the.
That is what, no? This is what. Though have been held to be ultra-virus by this court. In the case of Borkotoki, MS Borkotoki Print and Media Services and others versus Union of India reported in so and so. But the said notification,
Yes.
but the validity and legality and validity of the said notification is presently pending before the Supreme Court.
That's right, my lords. I gave a table, my lords, where it is pending.
Division bench of this court.
Supreme Court. I know that.
That's right,
To the Supreme Court. No, because the division bench appeal is there. There's no fight. But all over India, this has happened. No?
Yes,
Some high courts passed in favor, some against.
That's
I
right.
am only against.
Yes, your,
All others must have been in favor. So,
But what a well-considered judgment, my lords.
so therefore, that matter is now pending before, I think, Justice Pardiwala.
And my lords, we gave a list also of the matters which are pending before Supreme Court. It is in my lord's file, but my lords have already recorded.
GST Gauhati has not preferred an appeal.
That's right.
One GST which is pending is.
Mr. Counsel,
Yes, sir.
I passed that order and appeal has been filed before the division bench.
Yes.
Okay. Now, the matter went in Kerala, in Patna. Patna held that in view of the that judgment, that act, the limitation being extended by some act, what is that?
My lord, that is my lords, are my lords referring to the Supreme Court, my lords, order extending?
No, the Patna High Court.
All right, all right.
That is that act, no, the text by which the period was.
That's right.
So there, it was on that basis, it says that it was on the basis of that, it could have been done.
That's
And
right.
as such, it was held that the 56 is okay.
Mm.
And the matter rested there. Then you have Telangana High Court who passed an order separately.
That's right, my lords.
Then you have Kerala High Court passing another. Gujarat also passing another. All these.
And my lords, Punjab and Rajasthan simply said we'll await Supreme Court judgment.
Telangana went to Supreme Court.
Telangana went to Supreme Court. That's right, my lords.
Because of that, Telangana, the matter is pending.
That's right.
For our Gauhati, your worship, we have filed one writ appeal, number 20.
I know that.
That's why.
That is not relevant
No.
because the matter is pending in the Supreme
Yes,
Court.
yes, your worship. I understand.
The Learned Counsel further submitted that in so far as the notification number 9/2023 CT dated 31/3/2023, the division bench of the Kerala High Court have already held the same to be in consonance with law. This court have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. It is the opinion of this court that without going into the question of the legality and validity of the notification dated bearing number 9/2023 CT dated so and so, as well as the notification numbers 56/2023 CT dated so and so, the instant proceedings can be disposed of. The present petition, though, have challenged various notifications. But these challenges to the various notification is on account of the order dated so-and-so, passed by, order in original dated so-and-so, passed by the respondent number 7. The question, however, therefore arises as to whether without touching on those notifications which have been subject matter of challenge in the instant writ petition, the writ petition, the impugned order, an adjudication can be made as regards the legality and validity of the impugned order. Next. In the foregoing paragraphs of the instant judgment, this court categorically noted the two aspects on which the impugned order have been passed. First, the first aspect pertains to the mismatch between the GSTR 1 and the GSTR 3B. This court have quoted the table at paragraph number 93, as mentioned at paragraph number 93 of the writ petition in the foregoing paragraphs of the instant judgment. There appears to be no contradiction with the contents of the said table with what has been mentioned at paragraph 2.31 of the impugned order. More so, when it is the self-admission on the part of the petitioner that there was a mistake committed in submitting the GSTR 1, which pertains to outward
Statement of outward supply.
statement of the outward supplies. It is the specific case of the petitioner that there was a mistake in respect to furnishing of the GSTR 1 return, in as much as in 4 invoices, though the rate of tax was mentioned at 12%, but in the GSTR 1, so submitted, it was mentioned as 18%. Further to that, there was also an additional invoice which ought not to have been
It was a credit note, my lords.
an additional credit note, which ought not to have been a part of the GSTR 1.
It should have been reflected in GSTR 1 in minus figure, my lords. In minus figure.
Which should have been, there has been a insertion
Negative value.
of a credit note in the GSTR 1, which should have been actually subtracted, isn't it?
Yes, my lord. Yes. Yes,
Subtracted from the invoice value.
that's right, my lords. And duly so done in 3B.
And this aspect was duly reflected in the GSTR 3.
3B and GSTR 9 annual return also.
It is also the case of the petitioner that not only in the GSTR 3B, these aspects have also been mentioned in the GSTR 9. The question therefore arises that can this mistake which crept in the GSTR 1 be corrected subsequently? First, In the case of Abarde Technologies Private Limited and others versus the Central Board of Indirect Taxes and Customs and others reported in 2004, 105 GST 585 Bombay, the Bombay High Court, the learned Bombay High Court, allowed the assessee to amend / rectify the form GSTR1. A challenge to the said order passed by the learned Bombay High Court was made before the Supreme Court by filing an application under Article 136 of the Constitution. The Supreme Court dismissed the said special leave application by observing that the judgment passed by the learned Bombay High Court was just and fair, and there was no loss to the revenue. Paragraph 4 of the order in the case of Central Board of Indirect Taxes and Customs (SUPRA) is reproduced hereinunder. This court also finds it very pertinent to observe that the learned Madras High Court, in the case of Deepa Traders Supra, also following the judgment of the Supreme Court in the case of Central Board of Indirect Taxes and Customs Supra, held that the GSTR1, if the errors in the GSTR1 are capable of being corrected, taking into account the above, this court further finds it relevant now to take note of the observations made by the respondent number 7 in connection with the present aspect in respect to the mismatch between the GSTR1 and the GSTR3B submitted by the petitioner. Applying the explanation to section 7512, the respondent number 7 held that any excess liability shown in the GSTR1 vis-a-vis is an admitted liability and recoverable from the taxpayer. However, it is worth noteworthy to observe that the explanation was only inserted with effect from 1/1/2022. And the present dispute pertains to the financial year 2018-19. It is also noteworthy to observe, it is also important and relevant to observe that I will read. It is therefore the opinion of this court that as the petitioner in the GSTR 3B and GSTR 9 have mentioned as the petitioners herein have stated that in the GSTR 1 there was a wrong insertion of the rate of tax in respect to 4 invoice values. And the credit note which was required to be subtracted from the invoice value having not been done so. And these actually, and the rate of tax actually is shown in the invoices. Coupled with the fact that the self-assessments were made under Section 39 of the CGST Act have been filed in terms with the GSTR 3B. This court is of the opinion that the petitioner should be granted an opportunity to correct the GSTR 1 subject to placing necessary materials before the respondent number 7 that the invoices in question actually the rate charged, the GST charged was 12% and not 18%, as mentioned in the GSTR 1. Next. In regard to the second aspect,
My lord, before my lord's, with my lord's permission, my lords, because now the portal would not allow, my lords may say that manually I will file it before assessing officer.
Mr. Agarwal, are you going to write the judgment or am I writing the judgment?
No, my lord. All right, my lords.
Do you know how I write my judgment?
Yes, my lord.
Then you write the judgment.
No, my lords.
Then why are you disturbing?
Yes, yes. Sorry, my lord.
I allowed you to argue. Does it mean that
Yes.
when I am dictating the judgment in the court, you will say anything?
Sorry, my lord.
Not at the end of the judgment, you may say so.
All right. Yes, yes, my lord. Grateful.
This is not a thing we expect. And in
Yes,
fact, it's not a practice in our courts.
Yes, my lord. I'm
You
sorry.
may have it in some other courts, not here.
Yes, my lord. Grateful. My lord.
In respect to the second aspect, this court finds it very pertinent to, in respect to the second aspect, pertaining to whether the petitioner herein is entitled to claim the input tax credit for the month of March 2019, which was filed on 13/3/2021. And the same which was 13. The said issue appears to have been resolved by the amendment made to the CGST Act by the Finance Act 2024, giving it by inserting Section 16B, that too giving it effect from 1/7/2017, when the CGST Act came into force. This court finds it very pertinent to reproduce Section 16B, which was inserted by the notification dated 29/8/2017, bearing notification number so and so. Agati question no? A perusal of the said above quoted clause, above quoted subsection of section 16 reveals that in respect of an invoice or debit note for supply of goods or services or both pertaining to the financial year 2017-18, 2018, where is 18-19? Mr. Counsel, you are not going to get it. Because here 18-19 is not there, 19-20 is there.
Milords are reading, Milords, where Milords are reading, Milords?
Page 11.
Page
of the
11.
Violation.
Yes, Milord, one moment. Milords, it appears to have missed from here, Milord. The book.
So you have not produced this document, so you are not entitled to.
I'm sorry, Milords.
We therefore, on second aspect, we reject your prayer.
Milords may not do that, Milords. I'll just produce it, Milords, just after.
You have not produced it.
I'll just produce
know
it.
that you are doing the matter here. So you know that nobody will have a particular. You have a copy of that 16.5?
16.5, Milords. Let me just, Milords, just one moment, Milords, may give. Milords.
You have not given it. I told you, you have the, you are.
Actually, Milords, I'm sorry, I just missed that, Milords, that. I thought, Milords, it is reproduced, but it was, Milords have pointed out correctly. Milords, it is appearing at page number 36, Milords, of the judgment itself, Milords.
You have difficulty in trusting. Page 41 of the city.
Page 36.
Debit note or vote pertaining to the financial year 2017-18, 2018-19, 2019-20, and 2020-21. The registered person shall be entitled to take input tax credit in any return under section 39, which is filed up to 30th of November 2021. In the instant case, in respect to the return so filed, now in view of the said amendment to the CGST Act, thereby inserting section 16.5, the petitioner herein would therefore be entitled to claim input tax credit for the month of March for the GSTR 3B return filed for the month of March 2019 till 30/11/2021. In the instant case, the petitioner had submitted the return on 13/3/2021 well within the period stipulated in terms with section 16.5 of the CGST Act. Under such circumstances, in view of the amendment made to the Finance Act 2024, made to the CGST Act by the Finance Act 2024, thereby inserting section 16.5 to the CGST Act 2000 Act, it is the opinion of this court that the respondent number 7, that the opinion of the respondent number 7 in respect to the entitlement to claim input tax credit for the month of March 2019 is required to be interfered with. First, the above two aspects, as discussed and analyzed herein above, would therefore show that even without taking into account the challenge to the various other notifications, the impugned order which the petitioner is primarily aggrieved can be interfered with by passing certain directions. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The impugn order dated so and so, passed by the respondent number 7 in Namtudiri, is set aside and quashed. Number 2, the petitioner herein is directed within 30 days from today to place the invoices which the petitioner claims that the tax rate was mentioned as 12%, but was wrongly reflected in the GSTR 1 as 18%. And further, also show that the credit note of rupees 6,70,754 ought to have been subtracted from the invoice value. Full stop. Upon placing such materials, the respondent number 7 shall shall permit the petitioner upon materials before the respondent number 7 and the respondent number 7 being satisfied, the permission is granted, but the petitioner would be able to make necessary correction to the GSTR 1 return so filed. Number 2. Number 3. First. It is further observed that in the circumstance, the respondent number 7 is not satisfied with the materials shown by the petitioner in pursuance to the directions given herein above. The respondent number 7 shall be at liberty to take such course of action as is permissible under law. Number 3, 4. As already observed herein above, the imposition of any tax on late filing of the rejection of the petitioner's claim for input tax credit is not sustainable. And under such circumstances, the question of imposition of any tax on the petitioner on that basis does not arise. First, next. Taking into account that this court have set aside the impugn order dated so and so, passed by the respondent number 7, the question of imposition of any interest as directed in the impugn order also do not arise. Number. This court, now taking into account the above observations and directions and the above observations and directions and the Impugn order having been adjudicated without touching on the challenges to the various notifications made in the instant writ petitions, comma. This court observes that the disposal of the instant writ petition shall not be construed as rejection of any of the other pairs challenging those notifications by the petitioner.
I'm grateful. Extremely obliged.
For admission, item number 2.
May I please, Your Lordship? Lordship, for the state respondent, this matter is actually handled by my colleague Kiangami. He is in bereavement today, Your Lordship. So I'm seeking adjournment on his behalf. However, Your Lordship, if this honorable court desire to,
But isn't it covered now by the notification of 9/4/2023? You see, the petitioner herein initially asked for regularization and the regular scale of pay.
Lordship,
He gave up.
Lordship,
He gave that prayer.
Lordship.
What is left is as to whether the petitioner is entitled to be granted a regular scale of pay at par with other employees of the department.
Lordship,
Now, the petitioner was appointed as a substitute graduate teacher in place of one so-and-so whose service was subsequently terminated pursuant to a departmental proceedings.
Lordship,
Now, the petitioner has been working as a graduate teacher.
Lordship, Lordship.
Okay, there's a big problem.
Lordship, may I plead?
Hmm.
Your Lordship, I am appearing on behalf of the petitioner.
Hmm.
I would like to draw the attention of this honorable court to the dated 12/2/2026, Your Lordship.
Hmm.
Your Lordship, on this day when this matter was taken up,
Hmm.
only contention of the state respondent was that I am not possessing the same qualification, that is TED or BEd degree,
Hmm.
as per the other ad hoc employees of the department.
Hmm.
So on this issue, this honorable court has asked to the state respondent counsel whether the other ad hoc employees, they are also possessing the same BEd degree or not. To that, the state counsel has replied in positive that said that other ad hoc employees are also possessing BEd degree. So on that count, Your Lordship, this court has directed the state respondents to furnish the details regarding what, particularly, Your Lordship, I'm talking about ad hoc employees. Forget about permanent employees, Your Lordship. Only I'm talking about ad hoc employees. So as per that order, Your Lordship, at third page of the this order, it clearly says that state was that
You teach where? Where do
Lordship,
you teach? Where do you teach?
Kifri district, Your Lordship.
Huh?
Kifri district.
Kipri district, I understand. Which classes? Which
Uh,
classes?
Lordship, I was appointed as a substitute teacher, and in place with whom I was replaced.
Understood. No, Mr. Counsel, I'm asking you. You are a substitute teacher where? In which are the classes you teach?
3 subjects, Your Lordship.
In which class?
Class 3, 8, and third class is I am not sure, Your Lordship. I have to.
But these are all, what school is that?
Lordship,
What is the school?
middle school, Your Lordship.
Middle school.
Yes, Lordship.
Now, Mr. Suryan, my question is, can you at all be kept under employment, taking into consideration that the NCTE in the year 2010 have prescribed certain qualification to have in the school education, and this aspect having reached the Supreme Court, and the Supreme Court says that you cannot keep any teachers beyond 2021 or 24. who does not have that meet that particular qualification.
Lordship.
There you
Then,
have a problem. Forget about others, what they do. I'm not on that. But the question is, can you at all be a teacher without having that BA degree?
Lordship, in that case,
Hmm.
if I would ask the question,
Hmm.
unlike any other employees, still under education department, state government is taking the service of other ad hoc teacher or contractual teacher.
That is different. Others
Yes,
are
Lordship.
let them
Lordship,
be there. I'm
Lordship,
not on that. You are there.
Lordship, I mean to say,
Number 2. Yes. So in that
Lordship,
we are not on the question, but the fact that can you at all remain in employment? Because the moment we pass a direction that you should be given this particular salary, wouldn't that amount to recognizing that you are entitled to remain there?
Lordship, during my 13 years of service, I have never been intimated by my employer that I have to qualify for that degree. At least,
No, Mr. You need not be intimated. It is there as per under the Right to Education Act. And
Lordship.
with Section 23, the NCAT has already laid down the qualifications.
Lordship.
There,
Then, Lordship, if I was not possessing that qualification, then still why state respondent is taking my service? I have spent my 13 years of career in this profession.
so you want to go. Are you submitting that?
Lordship, I'm
My
only
question
saying,
is- My question is, do you want to leave?
Lordship, if
So
if
that-
I want to,
So that put that question out there to the state. The moment we put that question, they will be happy enough to remove you.
Lordship, as my appointment order, Lordship, as per my appointment order, it clearly says, that,
Mr. Counsel, the appointment orders would not do it, taking into account that it is now the mandate of a central legislation under the Right to Education Act.
Lordship.
Anyways, we do one thing. Won't dismiss your case today like that without the absence of Mr. K. Angami. Let him also, he is in bereavement. Why should I give happiness getting a dismissal?
Lordship,
Hmm.
as
But-
per the last order,
Mr. Angami here,
Lordship.
you are taking too much of adjournment on account of Mr. K. Angami. The matter came up on 12/3 also, you took the same ground of Mr. Angami.
Lordship,
You can't keep on taking
yes.
that, the same ground.
No, Your Lordship, a very unfortunate, incidents happened with my friend, with my colleague Kiangami, Your Lordship. What happened is,
But
he's,
that I understand. So therefore, when
Yes.
it is actually an unfortunate, take an adjournment. But
Yes.
don't take an adjournment otherwise. Because what happens like this, we still remember a particular folklore out here in Assamese, where a person always goes to a particular river. And while going into the river, he always used to shout, "The crocodile is come to eat me." And the people used to go there and then he used to laugh. And later on, when actually the crocodile came, no people came. So therefore, people stopped taking so much adjournments on account of Mr. Angami. Because earlier also you have taken
No.
12/3.
No, Your Lordship, in this case, the crocodile actually came, Your Lordship. For a fact, I'm sorry, I have to explain it this way, Your Lordship. In fact,
No, it's
just,
okay. I understand. I'll give you the adjournment because I don't want him now to be happy when he's in bereavement getting a dismissal in his absence.
Lordship.
Anyways, it has been submitted by Mr. N. Angami that Mr. K. Angami, the learned counsel, state counsel who is looking into the matter, is in bereavement and therefore submits that some time may be granted. List this matter again on 4th of May 2006.
My lord,
Lordship,
private respondent, my presence may be also reflected.
Lordship,
Hmm.
Lordship, I want to file additional affidavit because I could access some documents.
Liberty
which shows-
given to the petitioner to file additional affidavit, it's so this.
Lordship.
For
Lordship.
item number 3.
Yes, please, your lordship. The lordship, here I have a earnest request. On many occasions, this court has granted the state respondents time, and when the last chance was given. But lordship, here's a case where it's a land ownership case, and this PHC was established, formally inaugurated in 1988. But it was started way back in 1971. That's what I've been told. That's why it took time to collect all the records. But now all the records have been compiled, and we are waiting for approval of the pairwise comments from the government, lordship. So I'm hoping that by next week I can prepare the affidavit, send it for vetting, and file it, your lordship.
You are happy
2
with
weeks.
this interim order? You see that this court, by an order dated 27/5/2023, issued notice upon the respondents and further state the impugn office letter dated 25/2025 issued by the government of Nagaland Health and Family Welfare Department, Nagaland, till the returnable date. The record reveals that the petition has come up before this court on numerous occasions, and the state respondents have been taking time for filing the affidavit. Today also, when the matter is being taken up, time is sought for filing the affidavit. Accordingly, list this matter only upon the affidavit being filed by the respondent authorities. The interim order passed on 27/5/2023 shall stand extended till the disposal of the writ petition.
Obliged, your lordship.
What is holiday? What is open? Me.
For admission, item number 5.
Yeah, please, your lordship. On behalf of my colleague, Vito Zimomi, government advocate, I'm told that he has prepared everything, but due to some medical emergency,
What
he
is your
has
case,
not been able
Mr.
to file it yet, your lordship.
My lord, I am impugning the termination order of the petitioner on the ground that notice was not given, prior notice was not given for termination. And then the second reason is that
Where is the order?
the order is impugn termination. Page number 19, next to E. And no reason it's been signed here.
Did you receive any salary?
His lordship,
Did you receive any salary?
salary, I'm told that she did not receive any salary for the intervening period. If I may take my lord to the appointment order. 15 is the administrative approval, page number 15.
Have they replied?
Not yet, lordship.
There are
They have,
sanitation inspectors and MRC as well as so and so appointed under. State that with limited resources is not in a position even to manage the basic minimum of the existing. The understanding is of the considering the present state.
Next G is the reply to the representation for retention. It was replied on in 2023.
Your appointment is in 2022.
Yes.
Why didn't you apply in Kohima?
My lord.
You should have applied in Kohima. Kohima they are keeping. Not in Shimikidama.
Since she is residing in
Dimapur also they are claiming. They don't have money what to do. How can we exercise jurisdiction here, tell me? Yes, it is sad. But the fact is, yes, you were working for some time. The more you gave your joining report on 2/9.
yes.
In the month of October, they say that we are cancelling that. In fact, everything we are cancelling because we don't have money. We are overemployed.
In fact, my lord,
And those people who are there are also not in a position to pay them. How can we impose them on the basis of that?
Lord, my point is, at that point of time, when the termination order was issued, no reason was given. Only after my request for retention, only in 2023.
Understood, but then also they have given the reasons now. The reasons are that look here, we are not in a position to employ anybody. If they don't have anybody to employ, how can you impose upon them? That is why they are not filing. Otherwise, you don't need the affidavit. It is already there on record of which you have filed.
Yes.
Yes, in other places they are keeping.
Yes.
Sumigidema doesn't have money. So this is not a case of termination. It is not a case of termination. It is a case by which the very appointment order has been recalled.
Cancelled.
Taking they don't have money. Termination is different. Yes, yes. How is your colleague helping you out? Tell me.
My lord,
What is she suggesting?
I get the point, my lord, what my lord is trying to say. But then here in this case also, even to the extent that the petitioner has also expectation on the
Definitely, there is no quarrel. Every citizen has an expectation of being employed in government services. Everybody. But the fact that if it is a case of termination, it's a different thing. Termination, stigma, no stigma, all these things will come. But here, what they did, therefore, I asked you the first question: did
Yes.
you get any salary? You submitted your joining report, but thereafter, did you work? No. You didn't work during that period. You submitted a joining report. You didn't work for that period. So they recalled it, saying that we are not even able to pay. The only person who has been appointed as an ad hoc, on an ad hoc basis is some junior engineer in the year 2022, 2010, 20. Thereafter, they have not employed anybody. Well, waiting out here for last 4 years by you. You have filed in the year 2025. That is another interesting. 2022, something happened, 2025 year.
We have been pursuing within the
Understood,
department.
we are filing RTI, but the fact remains that it appears to be a meaningless exercise. They will keep on asking for time. At the end of the day, this is going to happen. Better, I think your client should be thinking something else, pursuing some other job out there.
No, sure.
No, he should. I'm saying whether he has done or not, that is his lookout. But he should, taking into account that they don't have money. Because you know, right, yes, on the basis of an approval appointment order, a right have started. But what they did, they didn't terminate you. They recall the appointment order saying that we don't have money. And tomorrow you work. If they don't have money, are you going to work? Tell me.
That will be subject to the instruction of the client.
Huh? You don't have money. If they don't pay, then if you work, they will keep him. Isn't it, mister? You don't mind keeping him if he doesn't want money, salary. Isn't it? Your only problem is you don't have money.
Yes, Your Lordship.
So you take your instruction if you want to do free of cost. Then he will keep him. Okay? Isn't it? But the instruction is going to be the same. What to do?
Let them file the affidavit. Let them file the affidavit.
It is seen that the respondents have taken various opportunities to file the affidavit. But no affidavit has been filed. A final opportunity is granted to the state, to the Chumigidama Municipal Common. Now that is also not
Now,
there.
yes, now election has been conducted. So
Okay.
But
To
that-
the Chumigidama Municipal Council to file the affidavit on or before 25th of May 2026, list the matter on 29th of May 2026.
Oblige, Your Lordship.
But don't ask your client to be more happy.
For admission, item number 6.
Please, Your Lordship. Your Lordship, the prayer of the petitioner is more or less has been addressed, Your Lordship. It's just a matter of time now, Your Lordship. Here, because of the petitioner is a overcharged employee, Your Lordship. Some verifications were going on because there were some discrepancies in the documents. Now the discrepancy has been rectified in the PIMS portal. Basing on this, Your Lordship, so maybe it is possible.
Now he will be receiving his salary.
Not now, Your Lordship. The letter is dated 13th March, Your Lordship. So,
Then
Your Lordship, after some interdepartment procedures are complete, Your Lordship, the petitioner will surely receive the salary, Your Lordship, because now the discrepancy has been removed and the approval has also been received. Now the discrepancy has been rectified in the PIMS portal, Your Lordship.
so you are going to pay him the salary from March 2026.
Your Lordship, with regard to that instructions,
That
I'm
is
not
there.
sure with the instruction, but
Now, kindly see March,
Yes, Your Lordship.
it says there.
It's with effect
Hence, you are
from-
directed to complete all necessary procedure and include his salary with effect from March 2026. So your case is that there was a discrepancy in the PIMS portal with the
with
Aadhaar.
Aadhaar.
And therefore, you were not, now that discrepancy has been removed, so now you will be paying salary from.
Yes.
Then Lordship, how about from 21st July 2021 till
We'll consider that. First, we first try to give you the salary now. We'll consider, we are not disposing of. We take this as the instruction that they are going to do it. I'll ask them to put it for an update in the month of April as to whether they have done it. Then we see why you are not entitled from July. Ms. So-and-so, who appeared on behalf of the state respondents, have placed before this court a set of instructions dated, a communication issued by the Chief Engineer PWD Housing, dated 13/3/2026, along with certain documents. The said documents, the said communication dated 13/3/2026, along with the other documents, are collectively kept on record and marked with the letter X. From a perusal of the said documents, it appears that there was a discrepancy in the credentials of the petitioner pertaining to his date of birth in the Aadhaar, in the PIMS portal, vis-a-vis the Aadhaar card. And this discrepancy have now been resolved. And there is a direction upon the Executive Engineer PWD-H to complete all necessary procedure and include his salary with effect from March 2026. Keeping that in mind, this court fixes this matter again on 24/2026 for an update as to whether the petitioner has been disbursed the salary for the month of March 2026. The entitlement of the petitioner for the salary with effect from July 2021 shall be considered subsequent on the next date. In the meantime, the respondents shall bring on record as to why the petitioner would not be entitled to the salary with effect from July 2021 by filing an affidavit on or before 17th of April 2026.
For admission, item number 7.
Same
Same, Your Lordship.
order.
publish?
Where is that? Correspondence. The said instruction is dated 13th March 2026, issued by the Additional Secretary to the Government of Nagaland, Housing, Work and Housing Department, to the Engineer-in-Chief NPWD, wherein it is mentioned that in respect to the petitioner, the discrepancy in the PIMS portal have already been rectified and migrated to category A. The said instruction is kept on record and marked with the letter X. Taking into account that the discrepancy have already been resolved, this court does not find any reason as to why the petitioners now should not be paid the salary from the month of March 2026. First, list the matter on 24/2026. for an update as to whether the petitioners have been paid the salary from the month of March 2026. This goes further. This court shall also consider on the next date as to whether the petitioners herein are entitled to their salaries with effect from July 2021 on the next date. A final opportunity is granted to the respondents to bring on record their stand by filing their affidavits on or before 17th of April 2026.
Blush. For admission, item number 8.
May I please, Your Lordship? I'm referring on behalf of James Newmeyer. He is a leading counsel for respondent number 6, and he has been engaged recently and will pay for some time to file our Vakalatnama. And
You have not filed Wakalatnama, matter is over. Now, what is the case? Whose case it is?
the petitioner are
Yes, what is your case, Mr. Suryan? You are there.
Yes, Lordship.
What are you?
Lordship, it's a case that I had taken loan from the respondent bank, and due to my personal reasons, I have stated in my writ petition, I could not repay my EMI on time.
No, Mr. Suryan, this is a different case. This is for appointment, some land ownership.
Oh,
You have just jumped in somewhere.
Lordship, I beg your pardon, your Lordship.
Yes, definitely you should.
Lordship, may I make a small submission? I've also been just recently engaged by
No,
respondent.
no problem. You don't have the petitioner today, but the fact remains what it is. You are appearing for the respondents,
Seven and eight.
respondents.
7 and 8.
But the question is, you see, the petition, the state respondents, they don't like to file. And it has been like a habit that 1 year is the minimum they should take adjournments. So we should therefore, I don't know, other coordinate benches may allow, but I don't feel like allowing this laxity on the part of the state respondents to have. For you, I understand. You'll obviously like to delay it, whatever may be. You may like to delay it. But we are always assume that the state is unbiased. Is it or not? Then why you are not filing your affidavit? 3 months have gone by. In the
Instructions have
principal
not-
stage,
yes.
if you ask anybody, when I issue a direction to file an affidavit, if they don't file, I consider it that these officials do not want to take the help of the government advocate. And therefore, the next day, I say I fix another date in a week's time through video conferencing to see the faces of the officials. Should we record that thing that they don't want to engage the services of the government advocates? None has appeared on behalf of the petitioner on call. It is also seen that the respondents herein have also not filed an affidavit. Mr. So-and-so appears for the respondent number 7
And 8.
and 8. And Mr. So-and-so appears for the respondent number 6. They also submit that they would like to file an affidavits. List this matter on 11th of May 2026. A final opportunity is granted to all the respondents to bring on record their stand by filing their affidavits on or before 4th of May 2026. It is also observed that in the circumstance the petitioner is not represented on the next day, this court would presume that the petitioner is not interested in pursuing with the instant proceedings.
From the supplementary cost list for admission, item number 19.
May I please, my lord? Lordship, I have a similar prayer even in this matter, lordship. If some time can kindly be granted, my lord.
Just for the record, Lordship, I understand the difficulty my learned friend is facing, but 6 times the government has taken time to file a counter. Lordship, this is a case that relates to fixation of my scale of pay.
And after passing an order, detailed order on 29/8, I've come after 6 months to this bench. Nothing is improved.
Yes. In fact, it was your Lordship who the file at the time your Lordship was here.
They have been taking time like anything. These adjournments must have been taken during the motion, the mentioning, no? I'll go back and tell the Chief Justice that one rule has to be there in the Kohima bench that there is no adjournment at mentioning. Because this is what happens. You see, all cases same. People, a person who has been
Deprived of the
appointed in 2000, not getting his scale of pay either under the 6th pay commission or even under the 7th pay commission. Therefore, has approached 7th pay commission came in 2017. After 8 years, he approached. Then also you don't file. What can happen?
Lordship, a short date may be given. So
No. The thing is, Mr. Is the state government's intention that there should not be any cases in the High Court? Is it the state government's intention that let the High Court become defunct? Because you see, why will people come to the High Court
Agreed.
if after 25 years he's not getting his dues?
Agreed, your lordship.
You see, approaching a person who has not got his salary as per the 6th or the 7th, and he's fighting out that and engaging an advocate to approach this court. It's a
Lordship.
very big thing.
Lordship, I
Meaning thereby that he has some faith in the institution.
correct.
And if the institution keeps on granting time like anything
Correct.
to the respondent authorities not to file it so that they can take time, these people will lose faith.
Correct.
And losing of faith means they would not come to the court.
I agree with my lord. I agree with you.
And which will result in not only the judiciary, or there will be nothing as regards the judiciary, it will also lead to anarchism.
Agreed.
The executive can do anything, don't you think?
Lordship, please.
So if you keep on filing, you doing whatever it is required, obviously the government will like to delay because they don't want the High Court to function.
Lordship.
Obviously, why will they? Because if I pass an order here giving him, wouldn't it be going against the executive? They don't like it. Why should I? So that's not file. And if the court also encourages by not granting adjournments to the respondents, every time you see, time is being taken.
Yes, Lord.
In the principal seat, we have around 57,000 cases. We don't have to worry on that.
Yes.
People still have some faith.
Correct.
We have here
Correct.
900 or 800 cases.
Correct.
It will come.
Less.
If you don't, if it is not done so, if you don't grant relief to the persons, it is not that the relief being always granted to the petitioner. The relief may also happen to the private respondent. A relief may be granted to the respondent also, the state.
Lordship.
But if it is the ball is not rolling or the wheel is not rolling, people will lose faith.
Yes, Lord. Lordship, I
For me, I can finish up this matter at 10:30 in a year, allowing all matters to be adjourned. Matter over, I can sit out there in my luxury, enjoy the lovely weather out here. Sitting out here till 4:30, writing judgments is not a matter of
Yeah.
joke. Don't you think?
Yes, my lord. In fact, I completely agree with my lordship. However, if I may be allowed to just to make one submission, in fact, the reality what happened is my friend KV, your lordship, within a period of 2 months, he has become orphaned. His mother died, and then this last
It's
Friday.
okay.
So these are
No,
some of
no.
the reasons why probably he could not file the.
Understood. All are understood. But the fact remains that for the petitioner, he has two counsels.
Yes.
But for the respondent, you have a panel of counsels.
Lordship.
So if somebody is not doing it, you see, you cannot, whatever may happen.
Yes.
Today, if somebody in my family died, should I keep on saying, okay, all the matters, should the High Court stop out here?
No, I understand that, your lordship.
It is, after all, a duty for everybody. I'm
Yes.
not saying about Mr. K. Angami.
Yes.
Obviously, he's in bereavement, he has to hear. But the fact that the High Court or the court cannot stop for that.
Correct.
It has to be taken up by somebody.
Yes.
And today, something happens in my house out there, so I have to go back. But then also I will be replaced by somebody.
Correct. I agree.
So that the High Court is functioning, there has to be a continuity.
I agree with my lord. I agree with you.
So it cannot be, and filing of an affidavit is different. You need to only file an affidavit whether the petitioner is entitled or not, that's all.
I agree, your lordship. But if your lordship taking that into consideration, if a short date can be
And now
granted to the
I'll
state.
give you a long date on 11th of May. I'm fixing it. On 13th of May.
Lordship,
12th of May, I'm fixing it.
Lordship.
You file your affidavit
your
by.
lordship has expressed so much, but I'm still the victim here.
Understood, Mr. Counsel. I'm putting it as a last opportunity.
That may be recorded.
I'm putting it. Don't
Because
worry.
my client has been
Obviously, you see the
very
pressure, a pressure which a client, once he has taken up this brief, a person has come to him, give me some relief, therefore he's coming. The pressure this counsel has to also endure. It's a very big pressure.
Agreed.
Yes.
Agreed.
When one practices out there, he knows that the amount of pressure you have. When I was a counsel out there, the only time we get always the problem with our clients out there, when is our case going to get listed?
yes.
In the principle,
Sometimes, David,
getting case listed.
Yes.
Just for example, in this case, list after 3 weeks has been given.
Yes.
In the principal seat, if it is given as list after 3 weeks, it is 3 years.
Correct.
It will never come up in the list.
Lordship.
So therefore, we fix a date.
Mm.
And here also, if you see, all my cases are fix a date.
Yes. Sir.
Once you fix, because I have, as a lawyer, I have faced this problem.
Lordship.
If it is listed after 3 weeks, it's 3 years. It is not. It is only in the principal seat it comes.
Lordship.
In the Kohima bench, it comes because there are less number of matters.
Mhm.
And he must have also asked the registry, kindly get the matter listed. Otherwise, the matter would not get listed.
Lordship.
So therefore, the thing is, you have to file your affidavit. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. N. Angami, who appears on behalf of the respondent state. Mr. N. Angami submits that there is a bereavement in the family of Mr. K. Angami, the learned state counsel, and as such, some time may be granted. This court duly takes note of that by an order dated 29/8/2025, a direction was given to the state respondents to bring on record the affidavit by filing on or before 11/9/2025. 6 months have passed by, but no affidavit has been filed. Mr. So-and-so, who appears on behalf of the petitioner, expresses that on account of not filing the affidavit, the instant proceedings have not progressed. And this is prejudicially affecting the petitioner. So taking into account the above, list this matter on 11th of May 2026. 12th of May 2026. A final opportunity is given to the state respondents to bring on record their affidavit by filing it on or before 4th of May 2026.
Yes.
Full stop. Liberty given to the petitioner to file a reply on or before the next date. It is further observed that in the circumstance the respondents do not file the affidavit, this court shall be constrained to take up the petition for final disposal on the basis of the materials already available on record.
Lordship, the degree of blush, and I sincerely apologize for the inconveniences.
No, it is not that. I have no problem out there. For me, I can get all matters adjourned, no problem. But this is going to affect. You see, this is a bench which needs to grow.
Yes,
and it will
correct.
only grow if it is.
Indeed. I'm deeply obliged.
Item number 20.
May I please, Your Lordship?
Hmm.
Lordship, this matter is inadvertently listed today. I believe the registry mistook the month. Yes.
The matter has been wrongly listed today, inasmuch as by an order dated 17/3/2026, the petition was directed to be listed on 24/2026. List the matter accordingly in terms with the order dated 17/3/2026. One more.
For orders, item number 9.
Let me complete the orders because second half there will be a lot of other matters which are there. Okay, so small matters, I'll just fix why the matters come. Why the matters come up for orders?
I'm representing Your Lordship, the respondent number 1, 2, and 5.
Is the service complete? Service in respect to respondent number, notice issued upon respondent number 4 and 6, registered post with so and so. Return post is still. Service is not complete upon respondent number 4 and 6. Are you appearing for respondent number 4 and 6?
3.
4 and 6. 4 and 6. Mission director to education missions, the Samagra Shiksha, I think it is the same education council who takes it.
No, Lordship, in fact, they fall under one autonomous body, Your Lordship.
I also understand.
Yeah.
But this is always being regulated by the education department.
Yes.
There's no quarrel with that. Mission director is there. And what is this Rehabilitation Council of India? You want to take fresh steps?
Lordship.
Take it by speed post.
Lordship.
Mr. Muajam, it is seen from the office note dated 16/2/2026 that the service upon the respondent numbers 4 and 6 is yet to be completed. Mr. Muajami, the learning counsel appearing on behalf of the petitioner, submits that the petitioner herein would like to take fresh steps upon the respondent number 4 and 6, taking into account the above. 4 and 6. You take steps upon 6 by way of Dusty.
Lord.
4 and 6. He further submits that insofar as the respondent number 6 is concerned, the petitioner would like to take steps by way of Dusty. Taking into account the above, this court directs the petitioner to take steps upon the respondent number 4 by way of speed post within 4 days.
Lord.
As regards the respondent number 6, steps be taken by way of Dusty routed to the registry of this court and file an affidavit of service on or before the next date. List the matter again on 12th of May 2026. In the meantime, the state respondents, as well as the respondent number 3, your 3, shall bring on record their stand by filing their affidavits.
For orders, item number 10.
The respondent number 5 is yet to be represented.
Respondent number 5 is not served.
We have taken steps on the 26th February law.
He's working.
Lordship.
He's working under whom? Respondent number 4.
Yes, Lordship.
Who is appearing for respondent number 4?
I am.
Okay. You give him her an extra copy. You get it served through your office to the respondent number 5.
Lordship.
It has been submitted, but that the respondent number 5 is working under the respondent number 4.
Lordship.
Taking into account that the service is not completed as regards the respondent number 5. Sir, this court directs Mr. Muajami, the learned counsel appearing on behalf of the petitioner, to serve an extra copy of the petition upon so-and-so by Monday.
Lordship.
So Ms. So-and-so shall effect service upon the respondent number 5 through the respondent number 4. Full stop. List this matter again on 18th of May 2026. In the meantime, the respondents are directed to bring on record their stand by filing the affidavits.
Lordship.
For orders, item number 11.
If I may, my lord, I am appearing on behalf of K. Romay, the counsel for respondent number 1. I pray for some time to file our follow-up sama. For all the respondents.
All respondents served.
Yes, my lord.
Lordship, I am appearing on behalf of the petitioner.
Who is appearing for 1 and 3?
I'm appearing for respondent number 1 and 3.
You are appearing. 1, 2, 3. Okay. Oh, service complete.
Yes, my lord.
Okay, service complete. List the matter for admission on 4th of May 2026. In the meantime, the respondents shall bring on record their stand by filing the affidavit in opposition on or before 27th of April 2026. Full stop. It is further observed that in the circumstance no affidavit is being filed, this court shall consider passing of interim directions on the next.
Lordship.
For orders, item number 12.
May it please your lordship.
Yes, Mr. Goel.
My lord, today the matter is fixed for consideration of interim prayer, your lordship. My lord, matter relates to my lord, petitioner is challenging the seizure made under section 110 of the Custom Act, your lordship, on the ground that initially the goods in question suspected to be of foreign origin, your lordship. My lord, thereafter, after seizure, my lord, petitioner approached the authority for provisional release of their goods, and the authority has changed their ground.
Lordship, to that effect, Lordship, I want to intimate this court that though I have sought the permission of this honorable court, after filing Lordship, it has been revealed that due to some inadvertent mistake in my affidavit in opposition, it could not have been placed before your Lordship step. Actually, the paragraph in the affidavit in opposition, we have to add the phone number of the deponent. So that is inadvertently missed.
Put the phone number. Call up and put the phone number.
No, but then from the registry, it has been returned.
You can very well put it again.
Yes.
The phone number you put it, I give you the permission
Lordship.
to put it.
Lordship.
We'll have it next week.
Lordship.
In the meantime, let the affidavit be brought on record. We'll have it next week.
Lordship.
Mr. V. Devnath, the learned counsel who appears on behalf of the respondent number 1 to 6 submits that though the respondents have filed their affidavit in opposition today before the registry, but on account of not inserting the phone number
Lordship.
of the deponent, the registry have not accepted the same. Full stop. This court directs the registry to accept the said affidavit in opposition after the petitioner herein inserts. The petitioner herein is given the respondents, the counsel for the respondent herein is given the liberty to insert the phone number of the deponent of the said affidavit in opposition. Upon doing so, the respondents, the registry shall duly accept the said affidavit in opposition by hand. Users is given the liberty to insert the phone number of the deponent of AR by hand, and the registry, upon doing so, shall duly accept the said affidavit in opposition. List this matter again on
26, my lord, if not inconvenient, my lord.
26.
My lord.
For 26, the registry shall bring on record the said affidavit.
Or consideration of interim prayer, my lord.
Interim pair shall be considered on the next date.
My lord, deeply obliged.
Lordship, you have mentioned serial number 21 and 22 has been fixed for 2 p.m. Account of constitution for that hearing. The matter has fixed for 2 p.m. today, hearing, for hearing, 21 and 22.
I know.
Lordship, this I wanted to just mention that so that I come from outstation for that hearing. And there's a division bench also, I understand, so I.
Division bench won't take time. It will be just 5 minutes. I would not even rise. I'll sit here.
look at VC not occasion. Oh. For orders, item numbers 1 and 2.
1 and 2.
No, please, Your Lordships. This, I know is filed for contribution of delay of 68 days in filing the resolution petition against the Honorable Court Judgment on the 9th of 2025.
Okay. 1 to 4 are private respondents, state respondents.
Yes, sir.
Miss Mary, you accept notice.
Yes, yes, Your Lordship.
What about respondent 5? I think notice is to be issued,
Yes, Your Lordship.
returnable on a fixed date. And if you request, we can permit Dusty also.
We can get it served through, because the respondent number 5 is presently working under the respondent number.
Yes, Miss Mary.
Yes,
You
Your
can
Lordship.
get it served through the.
Yes, yes.
Your Lordship.
Brother, then you dictate the order there.
Okay. Issue notice, this is an application filed for condoning the delay of 68 days in preparing the review application in respect to the judgment and order dated 9/12/2024 passed in the writ appeal number 20K/2024. Ms. S. Mary accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the petition, the present application be served upon her during the course of the day. As regards the respondent number 5, taking into account that the respondent number 5 is working under the respondent number 4, and an additional copy be served upon Ms. S. Mary during the course of the day, so that the service upon the respondent number 5 can be effected through the respondent number 4. This is the matter. When should we fix it?
Yes. Is there any condition in the listing?
After any.
In the office note, brother?
Listed again on. We can have it on 6th if it is not inconvenient. 6th.
Yes. 6th of April.
6th of. Issue notice making it returnable on 6th. Okay, brother.
Okay.
For admission, item number 18.
Yes, Your Worship.
Yes.
Yes, as advised by our Lordship, what they lose is the choosing of the village council. So if you go by the Nagaland village council like 1978, it is provided under section 14,
Village Council.
volume 3. 70.
No, not this one. Village Council Act. Volume 3. Page. Paragraph 14. The village council constituted under the law from the time to time shall administer justice within the village limits. Mr. Mimsong, shall you see? The village council constituted under the law in force from time to time shall administer justice within the village limits
Lordship.
in accordance with the customary law and uses as accepted by the canons of justice established in Nagaland and the law in this respect as enforced from time to time. Now, this petitioner is outside the village limits.
As per the provision, now it is too simple. That our provision is very simple. And again, the same thing is that Police Council Act, it was amended in the year 2022 also. So there also, there's a big amendment is there, section 14. It is
Because the
same thing
moment it has any respect to, if you see in case of disputes between villages falling in different areas, 2 or more village councils may settle the dispute.
also.
Meaning thereby, if a dispute is being constituted with a villager from another village, then it has to be 2 or more districts, village councils, or his village council,
Also.
along with your village council, their village council, together has to initiate. But can a person, yes, within the village, if there is anything out there, he can very well. Because the Village Council Act, basic is what? Only see why the Village Council Act was made. To consolidate and amend the laws relating to constitution of village and area councils in Nagaland, and to regulate and duties and functions for matters therewith. So their jurisdiction, village means and includes an area recognized as a village as such by the government of Nagaland. An area in order to be a village under this act shall fulfill the following. The land in the area belong to the population of that area or given by them by the government of Nagaland if the land in question is the government land. The village is established according to the uses and shall consist of members which so and so in accordance with the prevailing customary and users, and the same shall be approved by the so and so. So therefore, the village council would have the jurisdiction over its villagers, not over him. That is the only point. So we then keep the matter on Monday. This is just
Yesterday I was submitting that I had some prior.
this is your case.
Yes, Your Lordship, but
So therefore, now I am in your favor.
I know. Your
So
Lordship.
yesterday I therefore say the moment I am in your favor,
Yes, I know.
I will ask Mr. Siti Zameen to argue on Monday.
Yes, yes.
So I am now in your favor.
Your Lordship, Your Lordship.
So now Siti Zameen has to therefore come up with
Yes.
something
Yes.
which is something that the village council has the jurisdiction over any other villages, because
Yes.
your specific case is you are outside the village.
Yes,
You are not a villager of that village.
yes, Your Lordship.
So therefore, whether the village council will have.
Yes,
So if we see the power is only as regards 14.1, the village can consider under the law enforced from time to shall administer within the village limits.
yes,
So he cannot exercise the jurisdiction in which would affect another villager from another village unless it is done under 14.2.
Your Lordship.
That's your case.
Your Lordship.
So yesterday I said, na, if I am in favor of you,
Your Lordship.
then you need not, then I would only hear Mr. Siti. The moment I am hearing Siti Zamir, he is to the fact that I'm in your favor.
Your Lordship, one more thing. This. Yes, in this, Your Lordship, this is. If Your Lordship may go to section 14, the provision has been deleted, Your Lordship. In 1986.
So now, in view of this, has it been notified?
It is.
So if this is deleted, then village council has no power even to administer justice also.
Lordship, and then subsequently in the year 2022, another amendment is there.
There is another one.
It's more or less same with the whole.
So again, reinserted. Reinserted.
Yeah, I think.
So reinserted, but it has to be within the ambit of the villages.
Yes.
Village limits.
Yeah, as per the provision.
It is the same provision which is being inserted.
Yes, yes.
The village council shall function as village court as envisaged under the rules of administration of justice and police 1937. as amended and administer justice within the village limits in accordance with the customary law and uses as accepted by the canons of so and a law in that regard as enforced from time to time. Further, any appeal against the decision of the village court shall lie to the subordinate district customary court, and the district customary court as decided by the area administrative officer or the deputy commissioner. So your basic thing is, even if it is assumed under 1914
Yes.
he had no jurisdiction.
Yes.
Because if he has jurisdiction, the writ would not be maintainable, taking into account that the appeal lies before the district.
Yes.
The matter would be discussed by the submission will be given by the respective parties. But since I've been requested by your lordship that that is, as a court officer, I just want to share my view.
Absolutely.
This village council act is a guiding principle only, because those as a other day as I submitted, we have two category of village in the state of Nagaland. One is a traditional village. It was established way back, even pre-independence. And other way, we attend a statute that now the relevant law is enacted. So village council also act also enacted. So those act was see over the existing village council in certain cases. So in addition to this law, village council act, we have a custom also. That is my
Village?
custom, our custom.
Hmm.
Customary practices, traditional, everything is there.
No, my question is here. If a person has to derive power under the Nagaland Village Council Act 1978, it has to be the village as defined in Section 3. Every recognized village shall have a village council. So it is not any other village. A recognized village will only have a village council. So it may be you may have a traditional village or an ancestry village or a native village. The thing which have been, that day I was taking up the PI out there. The submission of Mr. Takamasa is that now they are permitting the recognized village to do so. But we already had a traditional native village at that one point of time. That is another aspect of the matter, but taking into account for operation of the Village Council Act,
Yes.
there will be a village council only in respect to a recognized village.
Yes.
Not anywhere else.
No. Even the traditional village, because of the system, it has become a recognized village. But traditional village, it has its deeply rooted in custom. So that's how.
So even if a traditional village, if it is not recognized, let us assume a traditional village is not recognized by the state government or is recognized as bifurcated into two villages. Then the Village Council Act will apply only in respect to the bifurcated two villages, not the original village.
Yes.
Because if you see, village means and includes an area recognized as a village as such by a government of Nagaland. So therefore, the recognition of the government of Nagaland is mandatory for the purpose of a village to have a village council. So therefore, the village council power has to be qua a recognized village. And if in a recognized village, if he does not belong to, whether that village council would have the jurisdiction over him. Because he is outside. It is something like we passing a judgment against a person in America. We don't have the territorial jurisdiction over them. The jurisdiction would have to be anything by the International Court of Justice. So something to that effect. So we will only have the jurisdiction for the persons here or even in a company in America, but having its branch office here.
Yes, Your Lordship.
So therefore, you have to, this is only, their jurisdiction here would be only limited to that,
Yes.
to the persons in the villages.
Yes, who are residing in the village.
So your, therefore, this submission of 14 being out has no relevance. Because by
No,
way
no,
of this notification,
yes.
14 has been reinstated.
Yes, my argument was only like that. Even if it is still in on the statute, it will not apply in my case,
But has it been gazetted?
Yeah, it's already,
No, it's in the Nagaland
Yes.
Gazette. Okay. Chalo. So I note down your argument and his and
Yes.
leave it to what Mr. C.P. Jamil will say.
Your lordship, no. And if your lordship may, if my presence should be required, one day I will be out of station. So Tuesday, Thursday, if it will be taken up. Thursday.
If I
So
change
that-
my mind.
Yes, it may be listed on Thursday again. I'll be returning on Wednesday.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. I. Fong, the learned additional advocate general who appears on behalf of the state respondents. And
120.
120. State respondents will include 120.
Yeah.
And you are appearing. Who is appearing? Mr. Muajami appears on behalf of the respondent number 5, and so appears for respondent number 4. Okay, so. The present petition has been filed challenging the orders, challenging the proclamation dated 12/8/2024 issued by the respondent number 4 in the newspaper. The letter dated 12/8/2025 issued by the respondent number 5, as well as the letter dated 19/8/2025 issued by the respondent number 5 directing the petitioner to appear before it. The submission on the part of the case of the part of the respondent of the petitioner herein is that the petitioner herein is a resident of Chuntiai.
Yes.
You are a resident of where?
Resident of Dimapur, your lordship.
Is a resident of Dimapur. Though earlier hailed from
The respondent number 5 village.
the respondent number 5 village. It is the case of the petitioner that as the petitioner does not reside within the jurisdiction of the respondent number 5 anymore, since
For so many years now, your lordship, I have to get the facts.
since
Yeah.
decades. One decade is 10 years.
Yes, yes.
Since decades.
Yes.
The respondent number 5 had no jurisdiction to direct the petitioner to appear before the respondent number 5 by the communication dated 19/8/2025.
Yes. And also the respondent number 4.
Respondent number 4 has not asked you to appear.
No, it is the respondent number 4 which is indirectly compelling the respondent number 5 to bring him on.
But-
Yes.
We are not concerned indirectly or directly.
Yes.
You are concerned with 19/8.
Okay, your lord.
In fact, the other two, this thing, 12/8, the proclamation
Yes.
by the respondent number 4 has no value. It is out there in the notification page, newspaper. If it has happened,
Yes.
it has already happened. I can't touch anything.
Lordship.
I can only touch upon 19/8. 12/8 and 19/8.
Yes, but even all these, those notifications and the directions issued by the respondent number 4 are also illegal.
No, that
So-
it is,
so
as regards the respondent number 4 in the newspaper, a
Yes.
proclamation being made
Yes.
by the respondent number 4 in the newspaper, it's a case of, what you call, it's a case of, any other case. It would not come within the ambit of
But the
jurisdiction.
summons, if the summons.
No, respondent number 4 is not summons.
No, it is. The respondent number 4, the initial summons are by the respondent number 4.
Where?
Your Lordship, page 33. This is by the respondent number 4 village. And then page 37. In my prayer, I have challenged all this, Your Lordship, in my prayer.
What is page 37?
Page 37 is another summon.
You have not challenged those.
Your Lordship, in my prayer, Your Lordship, if Your Lordship may go to the my prayer, my prayer.
It is the case of the petitioner herein, and that he is no longer for decades.
Yeah.
It is the specific case of the petitioner herein that both the respondent number 4 and 5 have no jurisdiction over the petitioner, thereby directing the petitioner to appear before the said respondent number 4 and 5. But Mr. Counsel, we have a problem as regards the prayer number 7. I can't allow for 7. Make it clear.
Your Lordship, yes, if they may file a proper suit before the.
That is a different thing. I cannot give you 4,
But
7 and 8.
But to someone.
But 8 is I will give you, but not 7. As
If-
per what I.
If.
7 I won't give you, 9 I won't give you, 10 I won't give you.
All these are.
Also,
part of
all
the-
others not given.
But if this honorable court finds that they have no jurisdiction.
That is what.
That will suffice, you know. That will suffice. And summons and all our questions set aside. No further.
In that
summons.
regard, the learned counsel referred to Section 14 of the Nagaland Village Council Act 1978. And submitted that the jurisdiction of the said village council is limited to administration of justice within the village limit and would not extend upon persons who are not residents of the village as defined in Section 3 of the Act of 1978. This court also takes note of that the respondent, this court also takes note of the submission of Mr. Imti Imsong, the learned additional advocate general, who submits that Why the Nagaland Village and Tribal Council? What is this? Is name is changed. Huh? There is another. By the Nagaland Village and Tribal Council (Fifth Amendment Act 2022), the Nagaland Village and Tribal Council Act 1978 was amended, whereby Section 14 of the Act of 1978 was reinserted. The Section 14 of the Act of 1978 as it stood when the Act of 1978 was enacted, which was deleted by the Nagaland Village and Area Councils Amendment Bill 1985 was reinserted thereby providing a scope of appeal. First, from the above, upon hearing the councils, this court prima facie finds that the jurisdiction of the village councils is limited to administer justice within the village limits. The question therefore arises as to whether the petitioner, who since decades is not a resident of the respondent number 4 village.
4 and 5.
5 is the council, na?
No.
4 is the.
These are true villages, Governor. These are true villages.
Respondent number 4 and 5. No, is not a resident of the Chungtia village as well as the Chungtia Yensem village.
Yes.
Would the respondent number 4 and 5 have the jurisdiction over the petitioner? As this court have heard, the learned counsel for the petitioner as well as the state, and as the respondent number 5, who is appearing for? Mr. Jameen is appearing for? 4. 4 is not present today. As the senior counsel who represents the respondent number 4 is not present today, this court fixes the matter again on Thursday.
No. Thursday.
You will be available Thursday. Are you sure? Thursday. Let's have it on 24th, 23rd, 24th. Well, I have because Friday I am not likely to sit here. So, because I don't keep any CAVs, so I'll dictate. So, 24th, on 24th, for further hearing.
for hearing item numbers 21 and 22.
Okay. And you mentioned that the state council Vector is on medical emergency service actions for the lordship.
Let us hear, madam.
The lordship.
Yes, madam, what is your challenge?
In this case, I just the brief facts first before I will proceed further. Actually, in this case, what has happened? The GST consultant who was handling the client's GST matters had issued fake invoices without the knowledge of my client. And after it came to the light that he has been issuing fake invoices, we have asked him to rectify it. And what he has done is to reverse that. He has taken the fake invoices from the same parties back. Then this was also again without the my knowledge. Thereafter, we have got the summons for the investigation started by the GST department. And in those summons, we have clarified ourselves that this is what has happened. These are the invoices.
Where is the notice issued under section 74?
Which notice? Summons. Summons people.
Well, I'm taking up WPC 129, which is the notice issued under section 74. Yes, so for notice, page 84.
DRC 01A was issued first.
Huh?
DRC 01A was issued first, intimation, ascertaining the liability of GST.
Now, kindly see this 84 page, whereas out of the total I ascertained and intimated to you by the order dated so and so, and you have voluntarily paid only the penalty portion of remand amounting to remand, so and the remand for the remand, therefore you ask to show why. Demand notice in DRC remand should not be issued to you for the remaining amount of the tax and interest. We shall proceed to issue you demand notice in 3 years under section without demand under where the enforcement or may had issued.
Lordship, no notice under 74 one was issued.
Huh?
Yes, Lordship, let me just I'll just take you to first. Can you see, Lordship, first I got received the DRC 018. Lordship, can you see at page 58? Intimation of tax determined in the DRC
Page?
Page 58.
58.
58. This is the intimation of tax determined in the DRC 018. Then there was another rectification of this order of DRC 018, which is at page 64. This rectification was also actually not rectification, which is again a fresh demand notice without giving any opportunity under 161. We have filed our objections. The objections are there in page number 67 that we do not admit this liability because
But these are just intimations till page 66. Then,
Lordship, after that,
then they are saying that we will issue 74-1.
yes, 74
seven-
is there, which is actually not a notice, because notice, it is asking that when will you pay the remaining amount? We have paid certain amount under process.
No, where is the order? Suppose,
That is
now
the-
here they
there is
have,
also demand order.
kindly page 84, so cause notice on the year. Please note that in the event of your failure to pay the indicated amount on time to time, date of demand, we shall proceed to issue your demand notice under section DRC 7 under section without further notice. Here also they keep on saying that demand order.
Demand order is come directly on it, like it is at page number 85. There is no other order.
Where is the order? Then you have filed an application for payment in installment.
Yes, installments.
Then
Under protest, Your Lordship, that is also under protest. But because there was a lot of pressure on us. But thereafter, we had filed for the refund of the amount paid before the deputy commissioner,
and
which he said that I'm not authorized for this, and then we have filed the.
now what is your case?
Lordship, the case, there are several irregularities in this case. I will start right from the DRC 01A intimation had come. Then we have made the payment under protest. It was not a voluntary payment. There is no DRC 04 was issued by them.
Now what are you asking for refund?
Yes, Lordship. And the caution of these orders, demand orders. Because this cannot be, Lordship, they have to give the show cause notice under 74(1), proper show cause notice and proper adjudication order. Without this is nullity in the eyes of the law.
We do one thing. We quash the impugn order, allow them to issue this, and the period during which this pending is going on, from the date of that order till date, will be excused, and they would let them file the issue the notice under 74(1) as they deem it. Otherwise, the period of limitation will go under 74(10).
Lordship, the limitation issue, if your Lordship is willing to give them the exclusion of this period. Lordship, they are getting fresh limitation because of that.
Obviously,
Lordship,
that
they
is what.
they have not issued the show cause notice.
So therefore,
Lordship,
you are
they have
challenging it.
deliberately pressurized
You
us
have
to pay
challenged
the
it.
amount.
You have challenged it here. We have the matter is pending. You challenged after 1 year. Then the matter is pending. Therefore, they have not there is a stay out there. So therefore, why they would not be entitled to the benefit of the if we are quashing that order, let them take a decision. If they want to issue a notice, they let them issue a notice under 74(1).
Lordship, then in that case, Lordship, I should be getting the refund of all the amount because
That
there
will
is no
be-
demand.
that will be subject to, if they don't issue a notice within that particular period of time, then you will be entitled to claim refund. You see, you made the payment in pursuance to 18(7).
Yes.
Once you made the payment, maybe under protest or whatever, maybe you made the payment. Now, what is happening is this entire 74 proceedings was null and void, taking into account that they have not taken into account, they have not issued a notice under 74(1). Now, without issuing a 74(1), they could not have gone into and passed an order under 74(5). There's no quarrel with that proposition. Now they have done so, so therefore we have to set aside the order of 18(7). But the matter having been pending out here, we give them 1 month's time if they to choose. If they don't, then you ask for refund, your refund application will be considered. That's it.
Lordship, there are two payments we have made. First, we have made the payment in pursuance of intimation. That was also under protest. Then second payment we have made after this demand order has come. So, Lordship, at least the demand what we have paid under protest for DRC 01A, that also, Lordship, should
That
be.
will be subject to outcome. The moment, therefore, I'm saying the one amount what you have paid, that will be subject to outcome of that proceeding. If they don't initiate within 1 month, if they don't initiate, we give them 1 month time to initiate. If they don't do it, then initiate. If they file a refund application, you will get it.
Then Lordship, may pass that amount is not a voluntary amount deposit. It has to
Understood.
be
What
unless
is
and until the
the
demand is.
Understood. Therefore, I'm holding it that it is not voluntary.
It's
I'm not saying that it is voluntary. I'm holding it is not voluntary. But the question is that will be subject to your filing an application for refund. Because if they don't take an action on the 74(1), now if they take an action within 1 month, which I'm giving it to them, if they take an action very well, that will be subject to the 74 proceedings. But if they don't take an action within days, you will be asking filing a refund application, they will give it to you.
My time limit for refund for 2 years also should be again.
Absolutely.
Should be counted from the.
Yes, because I am giving you the time, so that it has to be there because this matter is pending. So the benefit, if I am giving it to him, you should also get the benefit.
Lordship, would be a.
Worship, I'm representing the in here. Our office does not have any documents. Whatever you are suggesting, I think is approvable.
No, what has happened, you see,
Yes, Worship.
you have a CGST Act.
Lordship, I'm not carrying the act, so here, I'm not carrying the copy of the.
You have
act.
the Nagaland. Hey, okay. Take out section 74.
Yes.
This is printed when? When it is printed?
2025.
You'll find 74. Now it is 74A, na?
Yes.
70. Read it. Para one.
That one.
And I'll allow Mr. Longkumar also to hear it properly.
74, Worship.
74(1).
Determination of tax pertaining to the period up to the financial year 2023-24. Not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reasons of fraud or willful misstatement or suppression of facts, 74(1), where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded or where input tax credit has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been so paid or which has.
So there is a requirement of issuance of a notice.
Yes.
Now kindly see 74(2).
The proper officer shall issue the notice under subsection 1 at least 6 months prior to the time period specified in subsection 10 for issuance of order.
Now, this notice which you are to issue has to be issued prior to 6 months from the date the period would end as per 74(10). Now see 74(9).
The proper officer shall, after considering the representation, if any, made by the person chargeable with tax, determine the amount of tax, interest, and penalty due from such person and issue an order.
Then 74(10).
The proper officer shall issue the order under subsection 9 within a period of 5 years from the due date for furnishing of annual return for the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates to or within 5 years from the date of the error refund.
Now section 39. 39. 79 no, 39.
A moment here. Furnishing of returns. Every registered person other than an input service distributor or a non-resident taxable person or a person paying tax under the provisions of section 10 or section 51 or section 52 shall for every calendar month or part thereof furnish a return electronically of inward or outward supplies of goods or services or both. Input tax credit available, tax payable tax fee, and such other particulars in such form and manner within such time and subject to such conditions and restrictions as may be prescribed. Provided that the government may, on the recommendation of the council, notify certain class of registered person who shall furnish a return for every quarter or part thereof, subject to such conditions and restrictions as may be prescribed here.
So this return is to be submitted by September, no?
Yes, Lordship.
September of the,
Lordship, that because of the COVID period, lot of dates have been extended, so I. have
this
to
was
check the date.
extended.
Yes, some dates have been
These have
extended.
been extended.
Yes,
But if these have been extended we are concerned with the COVID period.
2021 Lordship is there also there.
How many years are there?
2021, 21, 22 and 22, 23. 3 years are involved.
2021, you are to file by September 2021. But this has been extended by various notifications.
Yes.
So
Even
if it is
22, 22
extended,
also even 21, 22 was also extended, but I do not.
21, 22 have also been extended
Yes.
to a particular period, if I
Yes,
remember
yes.
correctly. In one judgment I have delivered in the case of Borkotoki print and all, I have recorded with how much it was extended. Borkotoki print, in fact, that was the judgment where I had set aside the notification of 56, 2023. There I have detailed out which are the period where I have done so. So therefore, if it is 74 is to be exercised within 5 years from the
They still
end
have
of
time.
the year, I think they still have
still
the
have time.
limitation.
Lordship, then that is we reserve the right to challenge whether it is the case of suppression or fact mistake.
Oh,
That
no.
limitation we can.
No. Once they issue a notice under 74,
Yes. Then they have.
notice under 74(1), you have the right to reply. That is why the notice
Yes,
would be issued.
whether it is first of the extended period of 5 years is applicable to me or not, that I will reply once they issue the notice to me.
Absolutely. So therefore, but I think it is still within the period of limitation. If you see the judgment of Borkotoki, I have dealt specifically. Then I need not extend the limitation for them. It is already there if they want to take action. But it would not, then they would not be able to exercise the jurisdiction under 73. Isn't it?
Sure, but once the notices are issued under 74, and if by reason of it is caused that it is not suppression, then it is automatically become the notice under 73, provided it is within limitation. That already section 75 already provides for. If 74 doesn't survive, then it becomes 73 period is there available to them. If it is beyond that, then it is gone.
No, then if it
Then it
goes
is-
under 73, but the 73 limitation is less 3
It
years.
is less. It is less.
It is 3 years.
Yes.
But taking into as of now, it's 2026.
Yes.
So it is only in case of 74 they will be able to sustain because
Yes.
the period otherwise have elapsed. The last is something around 2023, if I'm not wrong. We are having a big problem with the internet also here.
Twenty-two, 23, they are in limitation for 73 also, but the first 2 years there might be a problem. Lordships may allow, since they have exercised 74, Lordships may allow them some time under 74. Whether 74 survives or not, that is the question to be determined later on.
No, I'm only looking into it because when dictating the judgment, I require those
Yes,
facts.
yes.
Because that facts has not been given here.
In the 2021, it is dated 74, since the annual return was extended to 28 Feb 2022. So they have time till 31st August 26. In for financial year 2021. So they are within limitation for 74 Lordship for all the 3 years. But they have more than 1 month.
You see, what they have done, the central government has done, that by section 44 of the Central Act stipulates the requirement of filing of the annual returns for every financial year in form GST and 9 or on before 31st of day of the December, following the end of, so it is not September, December.
December, 31st
Yeah,
December.
through a
yes.
common portal, either directly or through a facilitation center notified by the Commission. For the financial year 2017-18, the annual return was therefore required to be filed on or before 31st of December 2018. By notification number 8/2019 CT dated so and so, the central government, by exercising the powers under section 179 of the Central Act, extended the period for filing of the annual return to 31st of December 2019. Because this was the first time it came. Applying the above principle for the financial year 2018-19, the last date was to be filed by 31st December 2019. And that was extended, the last date was extended to 31st December 2020. By the notification, the period for filing the annual return for the financial year 2018-19 extended to 31st of March 2020.
Yes.
So we are not with 18-19.
18-19.
That by another notification bearing dated demand, the due date for filing of the annual return for the financial year was further extended for the state of Assam in respect to so and so. Now, so therefore, in the meantime, 68 came. Okay, then the GST Council recommended for extending the period in respect to the financial year 17, 18, 18, 19, 19, 20. 1920 is there, na? And accordingly for another 3 months. So therefore, the relevant portion of the so and so is so and so. The Secretary and Iman and Honorable Members so and so. On the way, the notification number 9/2023 CT was issued on 31st of March 2000, whereby the period for passing of the orders in terms with so and so was extended for final up to so and so, for financial years up to so and so and so and so. So 1920, what will be the last date?
1920.
We are concerned with 1920 now.
1920.
What will be the time for filing?
March 21.
March 21. 1920, we are concerned out here with 3 years.
What happened in DRC 018, 1920 is there, some penalties there. But since we had made some payment under protest, finally when they issued the demand order in that 1920s now. It is only 2021.
We are concerned with how many years? 2021.
If we see DR intimation, then 1920 is also there.
Now you are asking for challenging 1920 also.
Lordship, it is up to them. I do not know what.
No. In this case, are you challenging any order of any demand order of 18.7?
Challenging intimation under DRC 018, which contains 1920.
So therefore, 1920 is also the question.
1920, if they want to issue it,
No, madam. You see, 1920, what is the last date for submission of the final return? From there, 5 years has to be counted. Because if it is not so, if the time is not there, normally the time is not there, because otherwise it is 31st of March 2020, 31st of, 31st of December 2020. 1920 is 31st of December.
Time was extended.
How much it was extended? 31st March 21 also, you cannot issue notice.
No, time is from 30th September 25 was the last. 30th September 25 was the time to pass order. 74 order. For 1920, 30th September 25 was the last date for passing order.
How do you know?
Because 5 years if I count from that date.
No, if it is 31st of December 2020 is the date. Last date for filing the financial returns for annual returns for 1920. You say that it has been extended.
Extended is 31st March 21.
31st March 21. Now what happens is this, 2021. Now 5 years is 31st March 2026. Okay. Now the notice under section 74(1) has to be issued 6 months prior in view of 74(2).
It's why September 25. It's why September 25 notice. September 25 also.
No, there is no notice. No, if we are setting aside today,
Yes.
in the case of 1920, I have to give them some time because of the pendency of the instant.
Excluding the time taken for pursuing this writ.
So the pendency of the period from the date of filing of the writ be excluded while computing the period of limitation in terms of 74.5, 74.10. That is not 1 month, then it goes much beyond that.
The period of stay may be excluded.
What period of stay? The entire thing from the date you have filed the writ petition.
What the stay not immediately after filing the stay writ petition.
What? No, why should we enter in the period of stay? Yeah, 23/9/2024. This is it. So we exclude this period from the date of AS 3/7/2024 till date, while excluding the period of limitation. Then they will get the time.
Then it will be extended by 2 years.
Yes. Because of the pendency of the writ petition.
There is it is not.
It is not 2 years. It is not 2 years because of the fact from 3/7/2024 the matter has been pending.
Yes.
You have approached this court after 1 month, 1 year. We dismiss your petition on that ground. Forget about that. No, we dismiss your petition because an order of 18.7 is challenged on 3/7. We shall dismiss your petition. They will go to the division bench. Better off. Let us dismiss your petition.
Lordship, we were making the payments under protest.
So what? No, you are making the payment under protest, whatever maybe, you should have challenged it. You should have challenged and obtained the stay.
Lordship, there was lot of pressure on me. They were pressurizing us to make the payment,
So,
otherwise they will arrest. There
You
was
could
so much of-
survive.
There were a lot of
Madam, you could
Question.
survive in regard to the GST Council meeting on so and so had discussed the recommendation regarding paragraph where both the central tax administrations shall have the power to take intelligence-based enforcement. So this is law is clear. Now we exclude this period.
Lordships can pass now.
We exclude that they will have the time to take a decision on that as to whether they want to go on the 73 or 74. Also they can do it.
Which in the meantime only can direct that if we file the refund application, it can be decided as per law. If we file the refund application, it can be decided as per law because there is no demand. If there is no valid demand.
Let them
As
file
on
the
today.
application.
So if I file refund application, it should be processed. If they
Not process.
if they
You file your refund application. That is different thing.
yes.
Whether that is another subject matter of cause of action.
Yes, they can
No,
process
madam.
law
Today,
only
as
as
of
law.
now, you are liberty. The moment I set aside that order,
I am at liberty to file.
you are always at liberty to file. If it is not, it is a separate cause of action. Why should we now preempt that you are going to file? Then they would not give. Then I should say that you do it. No.
No, Lordship, I'm not asking that they should allow. They should only process. They should only pass the order.
How will I know that you are going to file? You file, then let us also have the pleasure of seeing you again here. Let me come back in 5 minutes. Why there are two repetitions, madam?
It's identical matters.
I understood. Why?
There are two different firms. One is two different names are there. One is Dimapur Diesel, second is Progressive Motors.
Now
The
here,
matter is same.
item number
21.
in 129, it is for which financial year?
Oh, it is fine. It's one show cause notice consolidated.
Hmm?
It is consolidated show cause notice. So it is all 3 years are in one night.
Now here the demand orders are passed for 2020, 21, 21,
DRC
20,
07 is
22.
issued for 3 different years, but the order is passed on one order.
Okay. And why then the other repetition?
The second repetition is a different
Person.
concern of both of the same assessee, but a different concern.
The different concern.
Yes.
So here the second repetition is 17 17.7. What is the difference? One is progressive motors. The other is Dimapur diesel. Okay, these are now I get
Dimapur
it.
diesels and
One is
progressive
progressive motors and the
and
other
this
is
is Dimapur diesels.
petitioner number one happens to be the same.
The proprietor of both the.
Anybody has that central or the state GST Act?
Yes, sir.
It is similar.
Yes.
Which is the form, madam, as regards 74?
Sorry, Lordship.
Or, you see, you are in Nagaland, so you need to also help these people. Otherwise, yeah, this becomes very difficult. And we face the same out there in, now what you call, when we are doing matters of, the CGST is very prompt. But the problem is with the state in in Assam also, the same problem, same.
They were prompt here also, but they.
No, no,
but
here
we
they are
shouldn't
prompt.
miss.
No. CGST is prompt means they know all the details, which form, how it's to be given and all. In fact, I feel that this act is, there's no, if you follow the act, there's no question of any challenge also. No challenge arises because it has been so well drafted. Everything, each rule is made properly. But the problem arises is they don't follow. They still stick to the earlier regime. That is the problem. Let's see. Now, as per GST DRC 1, there is no notice issued.
No.
Have they passed an order in DRC 7?
They've issued DRC 7 for that order, which I just showed you. In July, they have passed one remand order they have passed. For that, they have issued
In
DRC
fact,
7.
it appears to be like a DRC 01A.
DRC 01A was issued separately.
18.7 seems
Is
to
the
be
demand order.
Huh?
18 July is the demand order and DRC 7.
DRC 7 has to have the description of issues involved, description of the goods, services, if any, details, reference and text period, summary of the order. Where is it mentioned that there has to be an order in original? Under what provision? Summary of the
74,
order would be passed
itself,
here. The
no.
order referred to in Rule 5 shall be treated as a notice for recovery, where the rectification of order has been passed in so and procedure for recovery in this thing here. Information. But I found another provision, 175. 175. Under what provision is the order in original passed, giving reasons?
Lordship, they have passed under 74. They have written on the existing that it is under 74. It's a page number 85. 85.
So all these intimations which were being given were in terms with DRC 01A.
Intimations were given in DRC 01A.
1A.
Yes.
This is in terms with 142.2.
42. It is 1A. 142 1A.
1A, I'm sorry, 142 1A.
Yes.
So this is all these intimations prior to the DRC 07
Yes.
were actually DRC 1A.
Yes. Prior to issuance of show cause notice.
This has to be preceded. This
Yes.
should precede the notice under
Under
DRC 01.
Yes. In terms of 74 subsection 5.
74 subsection 5 is another thing. that gives the right of hearing.
It's the tax as ascertained by the proper officer.
24 subsection 5. The proper shall, if sufficient cause is shown by the person chargeable with tax so and so, adjourn the hearing for reasons to be recorded in writing, provided no further adjournment shall be granted for more than 3
No,
times.
74 subsection 5.
Or 70. No, the order which is being passed is person chargeable before the month pay the amount of reals when the payment of such in the amendment. It's okay. No, this is okay, but you see, in his order shall set out the relevant facts at the basis of it. No, this is, it seems that there has been an infraction to 75/6 of the Act.
Lordship, in fact, since once they issued 74 subsection 5 intimation, we did not accept that ascertainment of tax. We just paid some amount under protest because of lot of question. Then they are supposed to issue notice under 74(1).
Understood. No, that I understand. I understand. See, but prior to issuance of the DRC 07,
Yes.
there has to be an order passed in terms with 75/6. No,
74 subsection 9.
No, it's okay. That order will happen.
Yes.
74/9 is there. 74/9 is categorically mentions that he will pass an order.
Yes.
The proper officer, after considering the representation, if any, by the swearer with a man amount of swearer, this is given under DRC 07.
Yes. Summary.
I'm not
summary is
I'm not on that. I only see 75/6.
75. The proper officer in his order shall set out the relevant facts and the basis of his decision.
So this order has to be prior to DRC 07.
Yes, that order is not there.
Here, in this case, there is no notice.
No show cause notice.
So therefore, without that notice,
No
the question of
adjudication.
you submitting a representation does not arise. And once you submit a representation, there has to be an order passed under 75/6,
Yes.
which is containing the reasons, and the appropriate notice would be issued then under 74/9 in DRC 07.
Summary of notice comes under DRC.
So therefore, the procedure is in that manner. So initially, you have to issue a DRC 01A. After DRC 01A, if he does not make the payment, then you issue DRC 01.
Show cause, yes.
Then you have a right to submit your representation. Once you submit your representation, he has to pass an order stating the facts as well as the reasons. Once the facts and reasons are given or the basis of his decision is given, then you are to issue the order under 74/9
Yes.
in DRC 07.
DRC 07 as per 140, rule 140.
No, why I'm putting it is, there's a reason why I'm putting it because of the fact that these authorities should also know, na? The problem is there, not because of this.
Lordship, the DRC 01A is also invalid on two counts. First, it was rectification was done, which is not a rectification, it is a fresh DRC 01A. So there is a violation of section 161. Also without giving any opportunity of. So section
No, the
161
question-
mandates.
No, you see, what is DRC 01A?
It is the
This is
intimation
something
tax.
which is being thought of
Yes.
or a prima facie finding that you are liable to pay this. This is an intimation.
Yes,
You either pay or you may submit your representation. You pay under 144, 142.2, then everything will be dropped.
yes,
Now, if they pass on, you submit your representation out there. If you don't do anything, the following thing is they have to issue a notice under 74.1.
yes.
If they issue under 74.1 or 73.1, as the case may be, then you have a right to submit your representation.
Yes,
Once you submit your representation, he is bound to pass an order, which order has to be based on reason as per section 75.6. And this will follow an order under 74.9. If it is a case under 74.1, it's a 74.9 or 73.9 in the case of 73. And this order, once it is passed, the notice has to be issued under 74, under DRC 07.
07. Yes.
Why should we go into anything else?
No,
It is their first finding, whether it is rectification, no rectification, these are immaterial facts. Taking into account, it is for them. It is their prima facie. This is like an offer. Then look here, from these materials, we find that you are liable to pay.
Yes.
You may pay, you don't pay. If you don't pay, then the next consequence is the notice.
Yes.
So that has no material. Now, heard Miss so-and-so, the learned counsel appearing on behalf of the petitioner in both the writ petitions. Mr. So-and-so appears on behalf of the respondent, the Union of India. And Mr. So-and-so appears for the state. Appears for the Union of India. And so-and-so appears on behalf of the Nagaland State Goods and Service Tax. What is your name? What do you call it? Under the appears on behalf of the respondent number 2 and 3. They are same, na, in both?
2 and 3 are same.
That is the GST authorities of the state of Nagaland. The respondent number 4 is not represented when the matter is taken up. Next. The issues involved in both the writ petitions being the same, they are taken up for disposal by this common judgment and order. Madam, take a seat. However, for the sake of convenience and clarity in passing the directions, this court finds it relevant to take note of the brief facts which led to the filing of both the writ petitions. Then, Madam, heading, WPC number 129/2024. The petitioner number 1 herein is the proprietor of a firm in the name and style of MS Dimapur Diesels. The said firm, namely MS Dimapur Diesels, is registered under the Central Goods and Service Tax Act 2017, for short the CGST, bracket close, and have been allocated a registration number being GSTIN 13A BUPA 6964 C270. The present writ petition so filed challenges the order dated 18/7/2023 passed by the respondent number 3 under section 74(9) of the Nagaland Goods and Service Tax Act 2017, for short NGST. The materials on record show that the petitioner herein was issued a notice in DRC 01-A dated 4/11/2022. The petitioner number 2 was issued, wherein the determined tax, interest, and penalty for the periods 2019-20, 2020-21, and 2021-22 was mentioned. The petitioner, upon receipt of the said notice, sought for time for complying with the same. Thereupon, the respondent number 2 issued another notice under DRC 01-A for the financial years 2019-20, 2020-21, and 2021-22. It is, however, pertinent to mention that a perusal of these notices which were issued under DRC 01A categorically mentioned that these notices were issued in the context of Section 74 of the NGST, and further stating that non-compliance with the same would attract notice under Section 74(1) of the NGST. The petitioner on 24th of May 2023 submitted a reply be it as it may, on account of be that as it may, it is alleged by the petitioner that there was certain portion applied upon the petitioner, and resultantly the petitioner had to make certain payment under protest. And this aspect upon making payment was uploaded by the petitioner under DRC 03 on 27/6/2023. On 28/6/2023, the respondent number two had on 28/6/2023, the respondent number 2 have issued a show cause notice under Section 74(1) and 7, thereby intimating the petitioner number 1 that for the period 2019-20, 2020-21, and 2021-22, and 2022-23, the petitioner had paid only the penalty portion of 15%, amounting to rupees 12,11,020 for the period 2019-20, rupees 68,95,004 for the period 2020-21, and rupees 4,31,406 for the period from 2021-22 and rupees 4,37,926 for the period 2022-23. The petitioner number one was asked to show cause why the demand notice in DRC 07 should not be issued to the petitioner for the remaining amount of tax and interest as detailed therein. It does not seem that the petitioner has filed any reply to the said show cause notice. And this resulted in passing of an order on 18/7/2023. Wherein it was mentioned that a show cause notice was served upon the petitioner, and the petitioner, having not complied with the same, the petitioner was directed to pass the remaining unpaid dues within 15 days. The summary of the orders for the 3 financial years 2020-21, 2021-22, and 2022-23 were issued in DRC 07 on 18/7/2023. Madam, notice was issued.
Yes, Lordship.
Notice was issued. Show
Notice.
cause.
Show cause notice, but Lordship, that is a demand that you pay this amount. It is not a show
No.
cause notice.
Kindly come to 28.3, 28.6, page 84.
Yes, Lordship, this is show cause notice is written, but it is not a show cause notice.
It is show cause. Its category is
It
show
simply
cause.
asks that when you will pay the amount.
No. Therefore, you are asked to show cause why the demand notice under 07 should not be issued.
Lordship, why demand notice should not be issued? The show cause notice gives
So
the
therefore,
description
dear,
of
the
the.
notice is that. You have not understood that is your. Why didn't you file your reply?
Lordship, the show cause notice is not the show cause notice. It is why the demand notice should not be issued.
You then go and file appeal. This is have been duly complied. Or we can only interfere, saying to the effect that there is no orders. But you have not submitted your reply. Show cause notice was issued. This is done under 74(1).
So the show cause notice contains the particulars of the allegation, the demand, what is the demand, how it is arrived at.
The
Then only
demand
I
is
can
given.
reply, Lordship. This is the
CGST
amount
demand,
only given.
SGST demand and interest.
Yes, only the amount is given, but
There's
the
no
particulars of
requirement.
the demand is
No,
not given.
no, it is not required here. Kindly see this in the form. The form DRC 01 doesn't say so. You say that there was no opportunity of hearing. That can be the only ground, nothing else.
Lordship, a valid show cause notice contains.
It is a valid show cause notice. You know it
Nothing
very
is-
well.
Nothing, no particulars
No.
are there.
This is the form in which it is given. You were asked to pay that. You say that you are going to pay and then you have not paid. So this is it. Brief facts of the case given, grounds given, tax and other dues given.
There are several judgments of the High Court that the show cause notice does not contain particulars. The show cause notice is quashed. Show cause notice has to give everything. Otherwise, how a petitioner can file, assessee can file the effective reply if we do not know what is to be replied.
That is why DRC 01 has been brought in. That is why 142 1A has been brought in to the rules, saying that you are going to provide first these details,
Yes.
which he has provided.
Yes.
And in accordance to that, you have made the payment also under DRC 03.
Yes.
But what you have done? You have only paid certain amounts, not the entire amount.
Yes.
So therefore, you have only paid the penalty, but not the others.
Yes.
And you have not replied to this so cause notice.
Lordship, but
Why should you
it should
raise?
contain the allegations and
What allegation? Allegation is here that out of the total liability ascertained and intimated to you by so and so, 93 so and you have voluntarily paid so and so. Therefore, you are asked to show cause why the demand notice in DRC so should not be issued to you for the remaining amount of tax and interest indicated below.
Lordship, a show cause notice cannot itself determine the amount. If amount is already determined, then it is.
So
not a
therefore,
show
you are
cause.
supposed to. He will
It is
pass an
not
order.
determined.
No, madam, he will pass an order subsequently. So cause notice does not determine. You are to reply. You have not replied.
Lordship, see kindly. They
Yeah,
are
I think-
why the demand.
I think we
should not be
dismiss.
for the remaining amount of.
Yes, this is the amount.
The remaining amount of taxes, they are already decided that this is the tax you have to pay.
That is to be mentioned. It is a requirement of law it is to be mentioned the tax and penalty interest. What you have done when they issued the DRC 01A, it was categorically mentioned that this is the tax, this is the interest, this is the penalty. What you choose to pay only the penalty, but you have not paid the demand as well as the interest. So now what he says that you have only paid the penalty of this amount. Now why you should not be paid? This is a notice under DRC 1. So therefore, you are to therefore say that yes, this is not the amount which it is. You have not submitted your reply.
But the show cause notice cannot come with a predetermined amount that this is the amount and you have to pay the amount, remaining amount. They can say ki by the
No,
amount should not
therefore
be
you are
determined.
asked to show, no, read the language. Therefore, you are asked to show cause as to why the demand notice in DRC so and so should not be issued. Means it is the finality. Now, if you see DRC 01, it categorically says, DRC 01 categorically says, where is that? Yes, tax and other dues. These are already required to be mentioned. DRC 01. Summary of the so-called notice, brief facts of the case, facts has been given, grounds, it has been given, tax and other dues. This is to be mentioned. Tax, turnover, so and so, all these things have to be mentioned.
That is DRC 01 summary. But the detailed show cause notice comes separately here.
This is the this is the show cause notice. No, this is the show cause notice.
No, Lordship. Your Lordships have held your Lordships have held this. That if the detailed show cause notice does not come, then the summary of show cause notice is not enough. It cannot substitute the show cause notice.
No, I have held that the detailed summary of the not the show cause notice. I have said that the order which has been passed. My judgment is the order which I have passed under DRC 07, also there has to be a reason assigned there.
For DRC 01 also there are orders, Lordship. No. Yes, Lordships. Lordship, allow me to submit one order.
No.
Gauhati High Court only, Lordship.
Let it be. Go to the division bench.
Lordship.
Division bench.
Lordship, there is a judgment of your Lordship whereby your Lordship have said that DRC 01 cannot substitute the detailed show cause notice. This is just a summary. The detailed show cause notice cannot be substituted by this summary. And their show cause notice has not.
No, madam. That is a different case. There, what has happened? Nothing is being mentioned. Only one word has been mentioned. But here, they have mentioned this. You see this, my judgment out there to that effect. This is a different case. This has nothing to do, madam. This is a case to be dismissed. We should dismiss it. The order is right.
Lordship, in the judgment of Garg Associates, and this is para 9.
Not my judgment.
To para 9, Lordship.
Not my judgment.
Considering that,
Summary of the so-called notice DRC 01 as additional requirement or statement of determination of tax under 74(3) distinct from so-called notice. Authentication through digital signature is required. Opportunity of hearing mandate under 74(5) and principal. You may go on 74(5), nothing more than that. We can go on that, nothing more than that. So-called notice given properly.
one para,
No,
para 9,
no,
para 9 of this judgment,
no.
it clearly says that the
Issued
show
by
cause notice-
passing an impugn order upon 74. Notice under 73. B. Comma perusal in the so and so, Nikas so and so, the Lord's image of Karnataka has observed that the of so-called notice is a sign qua non to proceeding. Only is seen in the summary of the with the attachment contained. Termination of text can only say to a valid intimation under so and so. The summary of the so-called notice is in addition to the proper so-called notice. Here you may say at best, say that this is the summary of the so-called notice.
Yes.
No, this is the so-called notice. No, this is the so-called notice. But the summary on DRC 01 was not given. That is a different thing. But this is the so-called notice.
Lordship, but the show cause notice should give the reasons and circumstances clearly. It is there. Why this issuance of the notice? That is not given.
Issuance of notice is clearly given.
No, it is not giving the circumstances. Lordship,
The circumstances is clear. Circumstances is very clear. So therefore nothing remains. I can ask you to submit your reply there. That is the best I can do. Nothing more than that. This is done properly. Chalo. The petitioner, therefore, has approached this court by filing the present petition on 3/7/2024. Almost 1 year from the date of passing of the DRC 07, passing the orders dated 18/7/023 in DRC 07. WPC number 130/2024. The petitioner number 1 is the proprietor of the petitioner number 2. The petitioner number 2 is registered under the CGST and have been issued a registration number being GSTIN 13ABUPA 6964C1ZP. The petitioners have challenged the orders dated 17/7/2023 in the instant proceedings, which relates to the financial year 2020-21 and 2021-22. The case of the petitioner herein is that on 4/11/2022, the respondent number 2 had issued the tax determination order under DRC 01-A and determine the total tax, interest, and penalty for the periods of 2019-20, 2020-21, and 2021-22. The petitioner sought for extension of time for the purpose of complying with the said notice. Subsequent thereto, the respondent number 2 rectified its tax determination and issued again another notice under DRC 01-A, providing on 9/3/2023 on the penalty on tax, penalty, as well as the interest. The petitioner thereupon the petitioner's case is that under caution on 27/6/2023, and the penalty portion of rupees 23,15,044, 79,70,994 and 9,91,546 were paid on paid for the period 2019-20, 2020-21, and 2021-2022. This payment was made on 27/6/2023. A show cause notice was issued under Section 74(1) on 28/6/2023. For the years 2020-21 and 2022 to how many years? Show cause notice. A show cause notice was issued under Section 74(1) of the NGST on 28/6/2023. Wherein it was mentioned that pursuant to the liability ascertained on 9/3/2023, the petitioner had voluntarily paid only the penalty portion 15% for the period 2019-20, 2020-21, and 2021-22. The petitioner was asked to show cause as to why the demand notice in DRC 07 should not be issued to the petitioner for the remaining amount of tax and interest indicated therein. Thereupon, on 17/7/2023, the respondent number 3 passed an order stating that there was no compliance to the show cause notice served, and the petitioner was therefore directed to pay the remaining unpaid dues as indicated in the said order under Section 74 of the NGST within 15 days. In pursuance to the said order, the summary of the orders on 17/7/2023 for the financial year 2020-21 and 2021-22 were issued. The petitioner being aggrieved have assailed this order dated 17/7/2023 as well as the order dated 17/7/2023 as well as the summary of the orders in DRC 07 both dated 17/7/2023 by filing the present writ petition on 3/7/2024. The records revealed that this court initially issued notice but did not grant any interim directions. However, subsequently, by an order dated 23/9/2024 in both the writ petitions, the demand orders so passed on 18/7/2023 impugned in WPC number 129/2024 and 17/7/2023 impugned in WPC number 130/2024 have been were suspended. The interim order thereupon have been extended from time to time. The record reveals that the respondent have filed affidavit in opposition the respondent number one had filed affidavit in opposition in both the writ petition, stating inter alia that the investigation in the instant case have been carried out by the state GST authorities as is permissible under Section 6 of the CGST Act. In the backdrop of the above, this court finds it relevant to take note of the respective submissions made on behalf of the parties. Mrs. So-and-so, who appears on behalf of the petitioner, submits that the impugned orders of demand assailed in both the writ petitions is not preceded by a valid show cause notice, as is the mandate under Section 74(1) of the Act of the NGST. Inasmuch as to be a valid show cause notice, there has to be mention that the facts mentioned that there has to be it is the requirement of law that the facts constituting exercise of powers under Section 74 of the Act of the NGST Act have to be duly mentioned. First, the Learned Council submitted that Section 74 is an act, is a provision which can be initiated, which can be proceedings under Section 74 can be initiated in a case wherein it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit have been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts or to evade tax, which is completely different when there can be an exercise of powers under Section 73 of the NGST Act. Wherein the element of fraud or willful misstatement or suppression of facts is not there. The Learned Council, drawing the reference to the show cause notice which was issued on 28/6/2023 in both the writ petitions, submits that there is not a single whisper that the petitioners, the returns submitted by the petitioners, is on account of fraud is by reason of fraud or any willful misstatement or suppression of fact. The Learned Council therefore submits that the exercise of powers under Section 74(9) to issue an order in DRC 07 is totally contrary to the provisions of Section 74 of the Act of the NGST Act. The Learned Council for the petitioner further, referring to the said so-called notices which have been impured, so-called notices issued in both the writ petitions submitted, that without there being any allegation of fraud or any willful misstatement or suppression of facts to evade tax, the question of the exercise of power under Section 74(1) under Section 74 was not permissible. The Learned Council further submitted that the petitioner herein further submitted that taking into account the contents of the so-called notices dated 28/6/2023 issued to the petitioners, the petitioner did not file any reply. Be it as it may,
Lordship, may I just
An opportunity of hearing had to be given to the petitioner in terms with section 75(4) of the NGST. The learned counsel further submitted that in addition to the further submitted that a perusal of the order dated impugn orders dated 17/7/2023 and 18/7/2023, which have been assailed in both the writ petitions, would show that there is no mention would show that there is non-compliance to section 75(6) of the NGST, in as much as it obligates the proper officer to pass an order by stating out the relevant facts and the basis of his decision. The learned counsel therefore submitted that the impugn order dated the impugn orders dated 17/7/2023, as well as the orders impugned dated 17/7/2023 and 18/7/2023 in both the writ petition, therefore cannot be sustained in law. Yes, what were you saying?
should be the show cause notice as issued by another officer. Order is passed by another officer. The show cause notice does not give particulars before whom I have to show cause, because the enforcement officer cannot pass the adjudication order. Order is passed by different officer. The show cause notice ideally should contain the name of the officer where I have to give the reply. So that is also not there in the show cause notice. So the show cause notice is actually not a show cause notice. He said that he will issue the demand notice. Then the demand order comes from some another officer. Because he cannot pass the adjudication order, enforcement officer.
The learned counsel for the petitioner further submitted that a perusal of the show cause notices issued in both the writ petitions that dated 28/6/2023 would show that the show cause notices have been issued by the respondent number 2, whereas the orders dated 17/7/2023 and 18/7/2023 have been made by the respondent number 3. The learned counsel submitted that even assuming for argument's sake that the show cause notices dated 28/6/2023 in both the writ petitions can be said to be show cause notices, but the non-indication in the show cause notices that the reply is to be filed before a particular officer and before whom the hearing would take place, violates the very mandate of section 75 of the NGST Act. Per contra, the respondent number so-and-so, the respondent authority submits that in the incident case, the petitioner herein was issued notice, and petitioners in both the writ petitions were issued notice under DRC 01A, informing the petitioner that the petitioner was liable for the respective financial years, the amount of tax, interest, and penalty. The petitioner thereupon made certain payments, as would be seen from a perusal of the writ petitions. However, did not make any payment of the total amount, which necessitated the state authorities to issue the show cause notice in terms with section 74(1) of the NGST Act. The petitioner thereupon did not submit a reply, and under such circumstances, the impugned orders have been passed. The learned counsels further submitted that the petitioner had an alternative remedy of preferring an appeal against these orders under Section 107 of the NGST Act. However, no appeal thereagainst was filed and had approached this court by filing the present writ petition. The learned counsels further submitted that this is not a case where the jurisdiction or authority of the respondent authorities to pass the impugned orders have been assailed. It is a case whereby the effective and efficacious remedy would be before the appellate authority under Section 107 of the Act of the NGST Act. Anything more?
You were also, they also replied to the written submission, submitted a written submission. It is DRC 01A before the authority, if it can be added. So that they were aware that fake invoices, those allegations were made against them.
The learned counsel for the petitioner, the learned counsel for the respondent also submitted that upon issuance of the notice in terms with 142(1)(a) of the Central Goods and Service Tax Rules 2017, which is applicable in so far as the NGST Act is concerned. In form DRC 01A, the petitioners knew that their case pertained to suppression of the case came within the ambit of suppression of facts to evade tax. And this aspect would be apparent from the fact that the petitioners have submitted a reply stating inter alia that the petitioners were not responsible for the evasion of tax as alleged. The learned counsel further submitted that this very aspect is also apparent from the very writ petition wherein reference have been made in respect to one Anupam Roy, for whose actions, for whose alleged actions the petitioner, the petitioner, in some action of one Anupam Roy. The learned counsel therefore submitted that in the instant case, the question of interference with the impugned orders dated 17/7/2023 and 18/7/2023 as assailed in both the writ petitions do not arise. We do one thing. I'll pass the remaining order tomorrow, Monday.
Okay.
There, I will put it to that effect. Let the heart ripen because we don't sit after 14th. I'll pass that order. The show cause notice is not proper, then they will issue a proper show cause notice, you give a reply. And the period during which the writ petitions have been pending shall be excluded while computing the period under 7410.
Okay.
Because here, madam, everything closes at 5.
Yes.
So that is why, because they have a problem.
Yes.
In Gauhati, I keep on sitting till 5, but here it will not be proper.
It will be kept for Monday.
Monday, I'll pass the remaining order. In the court itself, I'll pass. I don't keep CAVs. Monday, we'll pass it at 2. You can be there on the video conferencing. You can be there in the video conferencing.
Yes, yes.
Madam, you just put it, list the matter again on Monday at 2. Today? Today I can't, no. It's 4:30. I am not completing it because of that, because there will be some more. Or I can do one thing, but this is the order which I'm passing. We set aside the show cause notice, impugn order on the ground that the show cause notice, because if you are exercising 74, you have to give reasons. Why 74? Otherwise, it's a case of 73. 73 also, there is a case of willful suppression is required. You have to mention that when you are issuing that. So that basic fact is to be there to constitute a notice. Otherwise, normally what happens? You file in a GST, you file your returns. It is always self-assessment. So when you are exercising some additional power, or you are overseeing this self-assessment, then obviously you have to give reasons that there has been escapement of income or whatever maybe this has to be. So therefore, this basic fact is required in that notice. Yes, other matters, Mr. Counsel, you have been waiting every day.
Lordship,
25th would be a Wednesday.
Lordship, regarding item number 16, if your Lordship kind enough, then this matter can be fixed on Monday, 23rd of March, this coming Monday, your Lordship.
Mr. Counsel, don't you see there is another senior counsel waiting out here who is making a submission and then you are intruding upon it?
Lordship, I beg your pardon, your Lordship.
Yes, tell me. What is your matter about?
It's in connection with suspension and payment of the system.
Oh, suspension, that matter, I have fixed it today. Okay, they said that, okay, we have it on Monday. Tuesday. Okay, then we'll have it on Thursday. There's another matter, I fixed it immediately after motion. That is another suspension. Okay, oh, that suspension I have. Okay. This is yours is a suspension from termination. From a job.
Yes.
Okay. This matter on 26th. It's for in hearing.
Yes, it's in.
Sure. 26, don't put so many matters. Anyways. Yes, Mr. Surya.
Yes, Lordship, regarding item number 16, your Lordship, if it could be fixed on Monday, your Lordship.
Why? What is
Lordship?
Not my. See, Mr. M. Tuesday.
Tuesday. Lordship.
Provided not from there.
Lordship.
Okay, Tuesday.
Obliged, Lordship.